Hello, welcome back everybody to another episode of True Crime Metrix. What's that? A double playing intro? No, it's just my own video. In the background. Close tab, please. Yeah, welcome everybody. Donna Adelson back with emotion. But not emotion, because there's none of that. Just a motion, another written motion for the court. Yeah, it's quite funny. So I figured we'd just read it out, seeing as this is all hot for trot at the moment. Yeah, where do we have our motion? Let's hide your pretty face, Donna. See you, Donna. You'll be back. You'll be back. Okay, yeah. So this is Donna's motion to set bond and schedule Arthur hearing, which was filed on the 7th of February 2025. And it reads: in the Circuit Court of the Second Circuit in and for Leon County, Florida, State of Florida v. Donna S. Adelson. Defendant's motion to set bond and schedule Arthur hearing. The defendant, Donna S. Adelson, by and through undersigned counsel, and pursuant to Section 903046 Florida Statutes, State v. Arthur 390 SO2 717 719 Florida 980, and Florida Rule of Criminal Procedure 3.131, moves this Honourable Court to schedule an Arthur hearing, and in support thereof, and as grounds therefore says as follows. Procedural History. 1. Mrs. Adelson was arrested on November 13th, 2023, and on November 15th, 2023, she was indicted for the first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. The bond amount listed on each warrant for these charges indicated FAR, for first appearance required. 2. At first appearance, Mrs. Adelson was denied bond on count 1, and bond was set in the amount of $25,000 for counts 2 and 3. Number 3. On or about December 5th, 2023, the original counsel for Mrs. Adelson filed an emergency motion to enjoin the jail for an independent psychological evaluation or release to house arrest based on alleged violations of Mrs. Adelson's Sixth Amendment right to counsel. A hearing was held on said motion on December 11th, 2023. This Honourable Court found that there were no Sixth Amendment violations and entered an order denying the relief sought. Yeah. Number 4. On January 8th, 2024, a motion for substitution of counsel was filed, which was granted on January 9th, 2024. The attorney that became counsel for Mrs. Adelson was withdrawn from the case due to a conflict of interest on the eve of trial, September 17th, 2024. From a review of the records, it does not appear that the issue of bond was ever addressed by this new counsel. 5. Due to the conflict of interest, Mrs. Adelson's pretrial confinement in the Leon County Jail was extended for approximately 9 months to await a new trial date. 6. The state of Florida has not filed a motion for pretrial detention. 7. The trial in this case is scheduled to begin with jury selection on June 3rd, 2025. General statements of facts. 8. On July 18th, 2014, Dan Markell was killed while sitting in his car in the garage of his Tallahassee home. Professor Markell was a prominent law professor at the FSU College of Law. Take some water here. 9. The Tallahassee Police Department began an extensive investigation which involved the FBI and law enforcement offices in multiple jurisdictions. On July 17th, 2015, Tallahassee Police Department released new details in the investigation. On May 25th, 2016, Sigfredo Garcia was arrested in the case. On or about June 28th, 2016, Luis Rivera was arrested in this case. Catherine Magbanawa is arrested on October 1, 2016. 10. On October 4th, 2016, Luis Rivera pleaded guilty to second-degree murder and he was sentenced to 19 years in prison, concurrent with his 12 years sentence in a federal RICO case. Sigfredo Garcia was convicted during a joint trial with Magbanawa in October 2019. Catherine Magbanawa was Oh, gotta turn the mic up. How loud do you want it? Up, 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 up. 1, 2, 1, 2, 1, 2. Is that better? Okay, I can't see chat. I'm reading. Welcome everybody in chat. Angel Baby, Kaza T, Mr. Pinto Peabody, and everyone else. Albert, Margaret, Colleen, John Duncan, of the Boston John Duncans, and Barely Legal Briefs. Okay. Welcome, Barely Legal Briefs. So, where are we? More? Well, hopefully that's loud enough for you. Audio volume, please. Hello! I'll bring the mic closer to me. How's that? Is that better? Yeah, that's better. I'm sure that's better. That's got to be better. What number were we on? Sigfredo Garcia was convicted during a joint trial with Magbanawa in October 2019. Catherine Magbanawa was retried and convicted in May 2022. Shortly before Magbanawa's second trial, Charlie Adelson was arrested on April 21st, 2022. Charlie was convicted in November 2023. 11. 1 week after Charlie's conviction, over 9 years after the homicide that took the life of Dan Markel, Mrs. Adelson was arrested at Miami International Airport. 12. The facts upon which the state of Florida indicted Mrs. Adelson was indicted for murder, first-degree capital felony. Well, I think that sentence could use a little work, a little love, maybe. The facts upon which the state of Florida indicted Mrs. Adelson was indicted for murder. There's no universe where that makes sense. Conspiracy to commit first-degree murder, felony 1, and solicitation to commit first-degree murder, felony 1, include substantially that Mrs. Adelson made derogatory comments about her son-in-law during the course of the divorce proceedings between her daughter and Dan Markel prior to the homicide. That she spoke to both her son Charlie and her daughter Wendy Adelson on the morning of the homicide. That law enforcement conducted a bump demanding money from Mrs. Adelson after the homicide, which she did not pay. That she signed paychecks out of her son's business at his direction to Catherine Magbanawa after the homicide took place, and that she attempted to vacation in Vietnam. She attempted to vacation in Vietnam, a country that does not extradite more than 9 years after the homicide. So they're still trying to make it like that. Like, yeah, it was just a vacation that she was attempting. A week after her son's life sentence. With good reason to believe that they're coming for her next. After the evidence that was played at trial. Are you kidding? Oh, this should be good. Incarceration Issues. Yeah, there's a few of these. Medical issues of Mrs. Adelson. Mrs. Adelson is a 75-year-old female with typical medical issues of aging, exacerbated by the conditions of confinement. Hearing problems that are compounded due to a medical issue that cannot be addressed by medical personnel at Leon County Detention Facility. Prior to incarceration, she saw an ear, nose and throat specialist every 3 to 4 months to have her extremely small ear canals cleaned out with proper equipment, as general flushing will not resolve her issue. My ear canals are too small for me to be in prison. I am Donna Adelson with my small ear canals. Okay. Severe pain from a pre-existing medical condition in her back and legs that cannot be relieved by the medical care available at Leon County Detention Facility. An excruciating pain in her left shoulder, down her arm, and into her hand, as a result of an injury received during an attack by another inmate at the detention facility. Within the past few months, Mrs. Adelson has begun experiencing shortness of breath that has reached the level where others comment about hearing her struggle to breathe. Undersigned counsel has actually had difficulty hearing phone communications with Mrs. Adelson because her breathing is so laboured that it interferes with phone reception. On a visit to the medical unit with other inmates on February 3rd, 2025, even the medical personnel asked where the loud breathing noise was. And the other inmates pointed at Mrs. Adelson. Oddly enough, when Mrs. Adelson was having a medical visit with the doctor at the detention centre prior to February 3rd, the doctor refused to even listen to Mrs. Adelson's chest, because that was not the reason we are here, and you will need to get another appointment with the physician's assistant. On Saturday, February 1st, in the early morning hours, Mrs. Adelson was in the bathroom area and accidentally bumped up against the washing machine, cutting herself on her right arm on a rusted metal bar on the machine. The nurse was in the pod, so Mrs. Adelson showed it to the nurse, who told her how bad it looked, but said she had no Band-Aid. The nurse told her to wrap it in toilet paper so that the bleeding would stop, and then to fill out a sick call form to request a Band-Aid and turn it in with the night nurse that would be there around midnight. Turning it in with the night nurse would mean she would get a Band-Aid the following morning. Unfortunately, the nurse had no sick call forms for Mrs. Adelson to complete, so there was no way to make a request. That'd be so much fun, wouldn't it? Just fucking with her like that. Yeah. Oh, you need a Band-Aid? No. You have to fill out the sick call form, okay? You have to fill one out and then wait. Oh, there's none left. So we'll put in a request to get some more of those sick call forms. Should hear back from somebody around midweek. Yeah, that'll be fun. I bet the guards are having some fun. And good on them. Got to do something to occupy your mind. Unfortunately, no way to make a request. Finally, on Sunday morning, February 2nd, at 10 a.m., a sergeant sent a Band-Aid down for Mrs. Adelson and also provided sick call forms which Mrs. Adelson filled out, requesting that each of her medical issues, including the cut, be addressed. You see, that's Donna right there, isn't it? She needs instant gratification. It doesn't happen. She has to wait 2.5 days to get a Band-Aid, and all of that time she's building a list. Building a huge list in her mind. It's practically a Sarah Boone move, right? To just get yourself so worked up for days. And then finally the forms get here and you just sit down and write down every medical ailment you can think of in alphabetical order. On Monday, February 3rd, Mrs. Adelson was finally taken to the medical unit. Her wound was cleaned and she received a tetanus shot. Mrs. Adelson needs medical care and simply cannot be obtained at the detention facility. She needs an appointment with an ear, nose and throat specialist, an orthopedist and a physical therapist at a minimum. If she remains incarcerated pending trial, the defense will need to prepare motions to seek permission for Mrs. Adelson to receive the care outside of Leon County Detention Center and obtain a court order for each appointment to be scheduled, which would then require jail personnel to transport Mrs. Adelson to her appointments. You see, what they're trying to do is say, oh, look, it's going to be loads of hassle for you, extra jobs if you say no. So you better let her out, otherwise you're going to have to pay for that transport to her appointments. There's not going to be any appointments. She might get 1 in the next 3 months. 2 at most. They'll take the extra work. Really weak argument. Obtaining proper medical care would result in a hardship for Leon County Detention Center and its staff. Yeah, we'll take it. It's what we do. Keep murderers locked up, yeah? Keep the public safe. That's what we do, okay? We're not going to let some murderer out onto the street just so we don't want to take her to the doctor. We'll take her to the fucking doctor. We'll pay for it. The American taxpayer will pay for it. 14. Attorney-client privilege. It is impossible for Mrs. Adelson to engage in attorney-client privilege communications via phone communication. You didn't need any more communications in there? Fucking hell. I know they're lawyers, but come on. It is impossible for Mrs. Adelson to engage in attorney-client privileged communications via phone communication. We're running out of patience with the lack of communication. While incarcerated in the Leon County Detention Center, within the pod, more than 60 other inmates have the opportunity to listen to her side of conversations. It is difficult at best for her attorneys to hear Mrs. Adelson when she speaks due to the enormous amount of background noise caused by static, phone connection issues on the tablet, and noise from the inmates in the background. Mrs. Adelson has had to get onto the bed and cover her head with a blanket so that she can hear counsel and counsel can hear her. A blanket full of ants. On one recent occasion, when Mrs. Adelson ended the phone call and pulled the covers off of her head, there was a guard standing over her listening to her phone call. Another inmate reported that the guard stood there listening for several minutes of the call. Once Mrs. Adelson ended the call, the guard proceeded to search all of Mrs. Adelson's items and discarded the headphones she uses to listen to the recorded materials related to her case, recorded phone calls, etc. Oh, does Donna do that every day as well, just like us? Lack of sleep. The schedule maintained for providing food and medication to the inmates at Leon County Detention Center results in Mrs. Adelson sleeping on average 2 hours each 24-hour period, and many times much less than that. A typical day for Mrs. Adelson is as follows. Nighttime medication distribution, 11:30 p.m. to 1 a.m. Sleep commences after inmates quiet down, 1:30 a.m. Awaken for breakfast, 3:30 a.m. Lay awake in dark on bed until lunch served. Lay awake in dark on bed until lunch served. Oh man, I bet Dan Markel would wish that he could lay awake in dark on bed until lunch served. But he can't, and he didn't have a choice. Lay awake in dark on bed until lights on, 3:30 p.m. Possibly leave bed and walk around in circles for exercise depending on who guard is. This is such a funny schedule. Dinner served, 6 p.m. What, you mean you don't lay awake in dark on bed until dinner served? Why not? Because you're walking in circles around the bed. Back on bunk until nighttime medication, 12 a.m. Riveting. Physical abuse. In addition to the initial period of incarceration previously complained of to the court, where Mrs. Adelson was placed in a cell with a mattress on the floor, where she had to lay without clothing for more than 50 days. Mrs. Adelson has been physically abused and threatened with abuse. Who wrote this? Mrs. Adelson has been physically abused and threatened with abuse. Well, okay, I guess that does make sense. It's still not great. Miss Adelson has been physically abused and threatened with abuse throughout her incarceration in the Leon County Detention Center. To understand the nature of some of these issues, it would be helpful for the court to be aware that the shower and bathroom areas of the pods at Leon County Detention Center have no security cameras and are not manned with guards for the safety of inmates. One of the first acts of physical abuse by another inmate took place while Mrs. Adelson was showering and was of a sexual nature. She thought she was alone in the area while she was showering when all of a sudden she felt another inmate run her hand up her entire spine from just above her buttocks to the area of her neck. The inmate asked Mrs. Adelson if she liked it, and in response, Mrs. Adelson, very frightened, began to scream, which caused the aggressor inmate to leave the area. Mrs. Adelson did all she could to avoid this woman during the remainder of that inmate's incarceration at Leon County Detention Center. Most recently, as Mrs. Adelson was standing in the area of and facing her bunk bed, another inmate slammed into her from behind, knocking Mrs. Adelson into the frame of the bed. This was very painful to Mrs. Adelson. When she turned around and asked why the woman had done that, the inmate replied, "Because you're a fucking killer." The most severe and frightening incident to date, however, occurred several months ago and, again, was in the bathroom area of the pod. Based on the records obtained Based on the records obtained, the incident occurred on or shortly before October 7th, 2024. Mrs. Adelson was bent over brushing her teeth with her right hand and leaning on the sink with her left hand. All of a sudden, she felt her left arm be jerked violently behind and up her back. As she was yanked in that direction, a much larger inmate told her that she knew Mrs. Adelson got canteen and that from now on she was going to get canteen for her too. When Mrs. Adelson tried to ask why she would do that, she was told by the larger inmate she was going to do it. Mrs. Adelson was scared for her life, and what more physical harm would come to her if she didn't comply. From that point forward, this aggressive inmate has instructed Mrs. Adelson what canteen packages she wanted ordered on a weekly basis. Afraid for her life, Mrs. Adelson began telling her husband to order the packages each week. She never told her husband why, and he just assumed Mrs. Adelson wanted the food for herself, because the meals provided by Leon County Detention Center are disgusting. After Mrs. Adelson receives her own canteen, purchased through the normal jail site, she also receives the 2 separate packages from the site ordered by her husband. She keeps the additional canteen items in the area of her bunk bed, and either the aggressive inmate comes to get the items herself or sends someone else to get items as she wants. This particular incident caused terrible pain to Mrs. Adelson on the day of the incident and has continued to this day. She has requested medical treatment from the jail for this pain on numerous occasions, but has gotten no relief. It has caused excruciating pain in her left shoulder that shoots down her arm, and at sometimes she even has a tingling in her fingers. Since the court heard the original motion by initial counsel, some jail staff, including supervisors, continue to take actions which can only be intended to punish Mrs. Adelson. For example, inmates are provided with locked storage bins to store commissary personal items. Mrs. Adelson has been allowed 2 additional bins for her legal materials. On more than one occasion by different officers, Mrs. Adelson's legal materials have been tossed out of her storage bin, resulting in hundreds of pages being tossed about and left out of order. Guards have commented in the presence of other inmates about Mrs. Adelson's perceived wealth, which led to additional requests by other inmates for Mrs. Adelson's commissary. Solitary confinement. Mrs. Adelson has attempted to seek medical care for her pain, shortness of breath, and other health issues for several months, and her requests for appointments have been routinely denied or not properly addressed. However, on Monday, February 3rd, when she was finally taken into the medical unit and all of her issues, including the cut, were being addressed, the physician's assistant asked about the pain in her left shoulder and arm and how it started. Mrs. Adelson disclosed how she had been attacked by a fellow inmate. Thereafter, without the knowledge of Mrs. Adelson, the medical unit reported the attack to jail personnel. Within a short period of time, 2 supervisors at the jail came to the annex where Mrs. Adelson and told Mrs. Adelson to roll up her bed and get her bins because she was being removed from the pod. They explained Mrs. Adelson had done nothing wrong and then took her into a room to question her about the attack. Mrs. Adelson was very reluctant to disclose any information because she truly fears retaliation by the aggressor and or her affiliates within the jail, of which she has many that Mrs. Adelson has already had to deal with. Mrs. Adelson finally disclosed all of the facts, including the extortion by the aggressor and how her husband unknowingly satisfying the demands by purchasing 2 extra packages of canteen each week to spare Mrs. Adelson of additional physical harm. Note, from October 7th to the present, Mrs. Adelson has spent $1,150 on this separate canteen. So how much is that a week? It's not much. It's like $100 a week, maybe. The jail supervisors advised Mrs. Adelson that it was their responsibility to protect her, and the only way they can do that is to put her in solitary confinement. Therefore, since Monday, February 3rd, Mrs. Adelson has been placed in a cell by herself. She is only allowed outside her cell on Monday, Wednesday, and Friday for 1 hour in the morning, and on Tuesday and Thursday for 30 minutes. Okay. When she is released, she has no contact with anyone else and can only use the time to shower, walk on the rec deck, or watch television. Other than that, she is on complete lockdown in a 6x9 room that has a bed, a toilet, and a sink. Note, the toilet is in full view of the window on the door that is approximately 4 feet across by 4 inches across and 30 inches high. Thus, can you start a paragraph with thus? Isn't that a... I don't think you can. I don't think you can start a paragraph with thus. Thus, the staff at the Leon County Detention Facility have determined that the only way they can adequately protect Mrs. Adelson from any future physical harm from inmates is to house her in solitary confinement. Therefore, Mrs. Adelson is being punished for having been physically attacked, injured, and extorted for the past 4 months. Yeah, well... So, what are you saying? That we should just let you out? Listen, you can either go and get extorted or sit in the room by yourself. You're not getting out. Your choice. No risk of harm to the community. Well, not now. Not now. What about back then? 11 years ago. Mrs. Adelson is a 75-year-old woman with physical impediments, with no prior criminal history and no disciplinary issues during her entire incarceration at the LCDC for the past 14 months. There are no allegations that she personally engaged in any conduct herself that resulted in any harm to anyone, including Mr. Markel. That's why she's charged as a principal. Not a flight risk. Mrs. Adelson has no passport and has been placed on a no-flight list, and thus cannot schedule a flight bound for any domestic or foreign destination. Her husband is 80 years old and would relocate to live with Mrs. Adelson in Tallahassee. That's funny. The place you really hate. Florida from release through the trial. Legal argument. Article 1, Section 14 of the Florida Constitution provides, until adjudged guilty, every person charged with a crime or violation of municipal or county ordinance shall be entitled to release on reasonable bail with sufficient surety unless charged with a capital offence. Murder's a capital offence, so your legal argument ends there. Or an offence punishable by life in prison. Well, that as well. Yeah, so we've got 2 out of 3. And the proof of guilt is evident or the presumption is great. Yes! Lots and lots of proof. Lots and lots of proof. We've got so much proof. It's just... the only question is, what order do we put it in? State v. Arthur 390 SO 2D 717718 Florida 1980. Emphasis added. 21. The Florida rules of criminal procedure provide that unless charged with a capital offence or as an offence punishable by life in prison and the proof of guilt is evidence of, the presumption is great, every person charged with a crime or violation of a municipal or county ordinance shall be entitled to pre-trial release on reasonable conditions. Yeah, well, you would say that. 22. Additionally, the Florida Rules of Criminal Procedure provide that unless the state has filed a motion... See, that S on state should be a capital letter. It's terrible. How can you go to the trouble of making a document like this and have errors? I'm sure that it doesn't make the judge happy when he has to read it and it's got clumsy errors. Unless the state has filed a motion for pretrial detention pursuant to Rule 3132, the court shall conduct a hearing to determine pretrial release. In State v. Paul 7 blah blah blah, the Florida Supreme Court held that the Florida Constitution provides 2 broad categories in which a person charged with a crime could be denied the right to be released on bond. 1, where the person is accused of a capital crime. This is just the same thing again. Or an offence punishable by life, where the proof of guilt is evident and the presumption great. Or 2, where no condition of release can reasonably protect the community, assure the presence of the accused, and assure the integrity of the judicial process. 24. The first category, requiring proof of guilt to be evident and the presumption great, has been defined as requiring the state... You see, you've got your uppercase letter here, haven't you, dickhead? Has been defined as requiring the state to establish a defendant's guilt is manifest, plain, clear, obvious, conclusive, and beyond question of doubt. Manifest, plain, clear, obvious, conclusive, and beyond question of doubt. Probably involves the 2 of us. Oh, and you can take me out to dinner, so make sure you bring cash. I need to bring cash. They asked you for money. Yeah, definitely. It's beyond question of doubt, Donna. 25. Where the evidence is arguably strong enough to sustain a conviction, but is arguably impeached in substantial respects by other evidence, or is rendered doubtful by substantial contradictions and discrepancies in the state's case, the proof is not stronger than beyond a reasonable doubt, and, accordingly, the accused is entitled to pre-trial bail as a matter of right. Well, yeah, but none of that applies. Start listing things that apply, okay? In Rodriguez v. Jenner, or Jenner? Rodriguez v. Jenner. Rodriguez petitions the 4th District Court of Appeal for a writ of habeas corpus after being denied bond at first appearance. The 4th District held that because the state did not file a motion for pre-trial detention pursuant to Florida Rule of Criminal Procedure 3132, the trial court did not have authority to deny petitioner bond and instead was required to consider conditions of release pursuant to Florida Rule of Criminal Procedure. While the charge in Rodriguez was not a capital crime, the rules of criminal procedure and Article 1, Section 14 of the Florida Constitution make clear the capital crimes are only treated differently if the state presents evidence that the proof of guilt is evident or the presumption is great. Again, reaching. 28. As noted in the Florida Constitution, the Florida Rules of Criminal Procedure, and the Florida Supreme Court in Arthur, this showing of proof by the states is prerequisite to pre-trial bail ever being denied. In Thornton v. Jr., the court held that upon a finding of probable cause for a capital offence, a defendant can be held without bond pending a full Arthur hearing. 30. If this court agrees bond should be set, Section 903046, Florida Statutes 2024, provides that the purpose of a bail determination in criminal proceedings is to ensure the appearance of the... Hang on. I'm just having a coffee here. Yeah, buymeacoffee.com. Buymeacoffee.com. Or just buy yourself a coffee. Criminal defendant at subsequent proceedings and to protect the community against unreasonable danger from the criminal defendant. 31. In making the determination of whether to release a defendant on bail and upon what conditions, the court is charged with considering numerous factors, including but not limited to A. The nature and circumstances of the offence charged. It's the worst one. It's the worst one we have. Top of the list, worst one, murder. Premeditated murder. And some other murder ones. B. The weight of the evidence against the defendant. Huge! Big, heavy weight. Like a jumbo jet on your little toe. C. The defendant's family ties. Length of residence in the community, employment history, financial resources, and mental condition. Okay, let's go through that one by one. Family ties. Well, they're getting low. Yeah, don't speak to the boys anymore, the Markel boys. Wendy can't speak to us on advice of her attorney. Son's in jail. Other sons, we exiled him. Hey, thanks so much, Pinto, for the coffees on buymeacoffee.com. Thank you, Pinto. Thank you, Sally. And thank you for the coffees, Pinto. That's so good. That's so nice. Oh, Neverly darling as well. Here you go, sugar. No sugar for me. Just black. Thank you for the coffees, Neverly darling. Fantastic coffees. What were we saying? Oh, yeah. Family ties. Well, there's just one, really, and he'll be dead in a year. So, length of residence in the community. Well, which one? Are we talking Broward County? Are we talking Miami-Dade? No, we're talking Tallahassee. They're going to move into 3303 Aqua Ridge Way. Imagine if they did that and then found some clue that Wendy had forgotten about. Her notes. Her early notes. Brainstorm. We've got to talk about Wendy's brainstorm soon. Okay. So, length of residence in the community. Employment history. Yeah. Just crooked bookkeeping. Long history of that. Financial resources, plenty, and mental condition. Well, they're working on it. D. The defendant's past and present conduct, including any record of convictions, previous flight to avoid prosecution. No, it was a holiday, vacation, or failure to appear at court proceedings. The nature and probability of danger which the defendant's release poses to the community. Well, what would she do? Like, have Jeff Lacasse assassinated? Start making calls the minute she gets out those gates. Alright, we want a hit squad. We're going to tag team this guy. You know. I want him in a very cold drawer by morning. Yeah, Jeff Lacasse might want to watch out. Who else would she kill on the witness list? Because they're members of the public. Obviously Jeff, sweaty, horrible Jeff. Junum Chinder, she's a loose end. No, you know, that no one's going to miss. People would be like, you know, for 2 weeks, they'd be like, yeah, what happened to that girl? You know, Asian, drove a white BMW X5 with a cream interior, had Louis Vuitton everything. Oh my God, look, Soap, there's a super chat or sticker from Angel Baby. Thanks so much, Angel Baby. Yeah. The defendants. Yeah, dangers to the community. Well, just the witnesses. I don't think she's going to do anything to the people of Tallahassee. Unless she gets really pissed off with the, I don't know, country. But oh, what's that? Wow, look at that. 6. Such a great number. 6 coffees. Thanks, Amy. Yeah, no, that's fantastic, guys. So where were we? Dangers to the community. Just the witnesses. The nature and probability of danger. Oh, no. We've already done that one. The nature and probability of intimidation and danger to victims. Yeah, the fucking Markel parents. They better watch out too. Any other facts that the court considers relevant? Well, you know, you don't have to get on a plane or have a passport to flee. You know, I'm sure that Harvey could find someone that smuggles people and money out of the country. You know. blah, blah, blah. These factors will be addressed by counsel at the hearing on this motion. Oh, can't wait. In addition to the issue of Arthur and pre-trial detention, and pursuant to Section 903046 Florida statutes, the court must also consider the current circumstances surrounding the incarceration of Mrs. Adelson, as well as the history of issues that have taken place and arisen. Simply stated, conditions of confinement for pre-trial detainees cannot be punitive. In Bell v. Wolfish, Wolfish is feeling a little sheepish. In Bell v. Wolfish, the Supreme Court stated that in evaluating the constitutionality of conditions and restrictions of pretrial detention that implicate only the protection against deprivation of liberty without due process of law, we think that the proper inquiry is whether those conditions amount to punishment of the detainee. For under the due process clause, a detainee may not be punished prior to an adjudication of guilt in accordance with due process of law. Interesting. Whether a condition of pretrial detention amounts to punishment turns on whether the condition is imposed for the purpose of punishment or whether it is incident to some legitimate government purpose. Magluta v. Samples. Moreover, it is not necessary for detention officials to expressly state they were punishing a pretrial detainee. A court may infer the purpose of the condition is punishment if it is not reasonably related to a legitimate goal of a jail facility. That's better argument. So he's saying, if it's not about flight and it's not about a danger to the community or witness tampering, which all of those things seem like she's really prone to do. I mean, you've got to get past all that, and if all the court's left with is retribution, pay your debt to the community, that should only come after an adjudication of guilt. But the thing is that you've got to get past all those first things. Risk of flight. Yes. Definite risk of flight. Give her an opportunity. You think she'll take it? If she comes up with something, she might just say, fuck it, we'll go out with a bang. Donna and Harvey taken out by a SWAT team at the border. Just gunned down in their prime. Well, a little bit after their prime. Quite a bit. At the end of days. Danger to the community, just the witnesses, like we said, but that is witness tampering, which could, pervert the course of justice. 36. Bell created a two-part test. First, the court is to consider whether any legitimate goal was served by the conditions. Second, the court must ask whether the conditions are reasonably related to that goal. Yes! And by the way, it's only another 3 months. Whatever the costs are to keep her locked down for 90 days, we'll do it. That's fine. Then she's being transported. I mean, I don't know why they're fucking wasting their time with this, This is a pretty lengthy document. It would have probably taken weeks to put together. You know, when you think about it. Yeah, they're doing other stuff, but thought has gone into it, and it's going to be a no. Is there any value in filing this so that it can be referred to on appeal after conviction? Maybe, but not much. I'd have just spent my time working on the case, you know. Waste your time with this shit. Like, do you think Judge Everett's going to fall for any of this? Like, whatsoever? Not one bit. Not one bit. 37. Although individually some of the conditions identified above may have a legitimate goal, the combined effect of the conditions in this case cannot serve any legitimate goal and are certainly not reasonably related to such goals. For example, the delayed medical care, timing of distribution of medications, conditions which lead to a lack of sleep, including the timing of medications, blatant violations of attorney-client communications by staff, as well mistreatment by some staff, and the physical harm inflicted by and threatened by other inmates. Conclusion. In summary, Mrs. Adelson is being held in the Leon County Detention Center awaiting trial under conditions that will result in her inability to receive a fair trial and unable to adequately participate in preparation for her defense at trial. Her health is failing. She is in constant pain. She cannot hear normal discussions, much less any reduced level speaking with counsel at counsel table, at trial, and she is not receiving a fraction of the amount of sleep necessary to assist in her defense. At this point, Mrs. Adelson is aware that the remainder of her time at the Leon County Detention Center, leading up to and during trial, she will be in solitary confinement without any access to interaction with other friendly inmates, art classes, or any other human contact whatsoever. Appointments with attorneys expected. Her incarceration should have ended upon the conclusion of her trial in September. Yeah, or just begun, depending on whether she won or lost. You know, it could have ended or continued forever. Through no fault of her own, her attorneys were removed from her case, and her trial continued for a period of more than 9 months. Thus, there, you see, thus is used not at the beginning of a paragraph. It depends on something coming before it, and not from another paragraph, thus extending her period of incarceration. Proposed conditions of release. Mrs. Adelson is aware she has to live with Judge Everett in his house. Those are the conditions. You want out, you have to live with Judge Everett. And he wants, you know, how are you at pudding, making pudding? Mrs. Adelson is aware of the seriousness of the offences for which she has been charged, and that the court would not consider the typical conditions of pre-trial release, and proposes that in addition to the monetary bond requirement, the court impose the following conditions of pre-trial release. Electronic monitoring. Mrs. Adelson will reside with her husband within Leon County, Tallahassee, Florida, pending the outcome of trial, with the request that the location be shared only with the court, the state, the defense, and the pretrial release officer for the safety of herself and her husband. comply with a curfew at the residence from 7 p.m. to 7 a.m., with the only exceptions being appointments with her attorneys for court and for medical purposes. So what? A curfew so she's got to be back at the house at 7 p.m. and can't leave again until 7. Well, that's all day out. That's just like a normal life. What are you talking about? That's not a restriction. Most of that time that you're at the house, you're going to be asleep. You're going to have dinner and an early night. And then out again at 7 a.m. for 12 hours. No. You can't leave the house. That's why it's called house arrest. A curfew at the residence. Well, thank you. From 7 in the evening till 7 in the morning. What were the other options? That you'd go out clubbing. Yeah, some defendants would want it the other way round. You're not allowed. You have to get back at 7 a.m. and you're not allowed out until 7 at night. And that'd be early. No travel outside of Leon County, Florida. No travel at all. Stay at the house. Report to the pretrial release officer on whatever schedule is deemed necessary by the court and any other conditions the court deems reasonably appropriate. Wherefore, the defendant, Donna S. Adelson, requests that this court grant this motion, change the venue for the trial in her case. And for, there's more. She wants more. And for such other and further relief as is just and proper. Blah, 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 blah. So that was a bit much, wasn't it? Fucking hell. Just went on and on. We've lost everybody in chat. Maybe we should put a video on. Yeah. Oh, we do have viewers. 83 viewers. Welcome, 83. Great. So what should we do now? Oh, there was a letter. We received a letter. So this is from February 3rd. So while Donna was in her solitary pod. Okay, there's some niceties at the beginning, but it goes on to say, here it's very difficult to enjoy anything. This is from Donna, right? Here it's very difficult to enjoy anything, especially the holidays when I would normally be celebrating with family and friends. This is an incredibly depressing place to be. We have not been taken outside to breathe fresh air since November 5th, almost 3 months. We cannot see outside either, as our windows are painted brown. I don't understand why these things are done to us. It's so cruel. Over the last month, our pod has been overrun with ants. They are coming through cracks in the building and are in our food and our beds. I wake up with ants in my hair. Of course, we've complained, but to no avail. You asked many questions, and I'll answer ones that I am allowed to respond to. I can only tell you that I had confidence in my previous attorney and was truly heartbroken when he was forced to withdraw from my case on the first day of trial. I couldn't believe that I had to start all over again looking to hire new legal representation. My new attorneys need to learn my case in a very short time frame. This is all very disconcerting to me. You asked what is the biggest obstacle I will be facing at my trial. I am being tried in Tallahassee. This city has been inundated with negative social media about my family and myself for 10 years. They would have to find jurors who have been living under a rock to not have heard about my trial or have an opinion. Numerous jail officers have told me that I must get my trial out of Tallahassee to have a shot at a fair trial. But the judge makes that decision. You asked how I spend my day. The woman I was teaching to read has left. I am helping another woman with an algebra course to help get her GED. There is very little to do here. We don't have a designated area to walk other than between other inmates' beds. I eat my meals on my bunk. The food is a high-carb diet. Potatoes, rice, or pasta for dinner, and grits for breakfast. Lunch is bologna or peanut butter. All very unhealthy. Everyone here gains weight because of the unhealthy diet and no exercise. I go to an art class 2 days per week, which is the only time I'm outside my pod. I cannot discuss the dangers here or the bullying, which is awful. Of course, I've been exposed to all of that, and yes, everyone knows who I am. I'm the only person in their 70s, and I stand out like the proverbial sore thumb. People that prepend with the proverbial. We know. You know. As always, thank you for the interest in my case. Yeah. Letters from Donna. Secret letters from Donna. So what should we do now? I feel like we should have a plan. I didn't really think too much past just having a look at that court document. There's that guy. King Tato. King Tato says, buy coffee. Oh. Do the hearing. Oh, okay, I guess we could do that. We'll head over to our channel page. We finally got all the Colin Griffith trial videos uploaded, folks. Going to be going through some of that. And we're going to do the grandma tonight. I still haven't watched the grandma all the way through. But we'll have a look at Donna's hearing from yesterday. With good old Judge Everett at the wheel.
Actually went to FSU Stroger Library yesterday, Judge. They're working on getting us some more documentation. We have filed a Brady demand. I think we have it set for a hearing, I believe, with your court. So I would ask that we would set this for that same day of that hearing, Judge.
What's that name again?
P-E-A-K.
I think that'll be 226. Be heard at the same time as the motion.
That'd be fine, Judge.
That's 226,
Yes, motion hearings on 2.
Man, watching Judge Everett from this angle makes me feel like I'm a menu being read, you know? If you were a menu being held by Judge Everett, this is what you would see.
26.
The next one is James Rackley, 2024 CF 2477. We are negotiating with the prosecutor, Mr. Hughes, about a resolution. If we could have 30 days,
Mr. Fuchs, anything to add?
No, Your Honor, he's asking me to be more reasonable, and I asked for reasonable reasons to be more reasonable.
and we're working on more reasons, making more reasons. Time saving for you, Your Honor.
325 at 2:30.
Dominic Rondinelli, 2024 CF 2769. We're trying to get more reasonable again with Mr. Fuchs. And, but I think we're working on a resolution. 325, is that the next one, Judge?
That is 325 at 2:30.
And the last one, Judge, I'm covering for Mr. Davis is 2024 CF 3341. State by prosecutor Fernandez is here. I think they want to set it for April. Case manager.
Mr. Fernandez?
That's fine, Judge. We're just starting discovery right now. No objection.
415 at 2:30.
Thank you, Judge.
What's the name?
Rajiv Shah, S-H-A-H, man.
Big man is.
415 at 2:30. Yeah, there's no room. There's no room. That's all right. Ms. Adelson, I'm going to send you a prompt to unmute on your side. Did you get the prompt? I see your lips moving, but we cannot hear you. One moment. I'll send it again.
I wish Judge Everett would send me a prompt to unmute myself. She's doing this on purpose. Just to take control over Judge Everett. Make him wait.
Yes, he needs to get set.
Okay.
All
Can
right.
you hear us, Your Honor?
I can hear you clearly. Let's go ahead and address Donna Adelson, 2023 CF 3226. Zellman?
Good afternoon, Your Honor. Joshua Zellman on behalf of Ms. Adelson.
Jackie Fulford on behalf of Ms. Adelson.
There's a couple of things that we wanted to address initially. The state had previously perpetuated the deposition testimony of Dr. Clark, the former medical examiner. That was done by prior defense counsel. We've reviewed the material. There was one portion at the end that we had requested that they edit out, but we would stipulate that would be appropriate to present to the jury during the trial in our case. We've spoken with Ms. Adelson about that as well. And even though we were not counsel at that, defense counsel didn't ask any questions, and that would have been our strategy as well.
Very well. You may continue.
We are also stipulating to the foundation of the extraction of Wendy Adelson's cell phone that was conducted by Marcia Rodriguez, who will be out of the country at the time of the trial, so that they don't need to present her testimony in order to introduce the contents through other witnesses. We did want to inquire with Your Honor about the status of the in-camera examination of prior investigator.
With that, Lynn, has a date already been set for that?
I don't think so. Did we didn't set a date yet.
And I provided his cell phone number.
This would just be me meeting with him. It's not a
Okay,
motion.
yeah, no,
Okay.
I'll follow up on that. We do have some issues with regard to discovery in a prior case management. Your Honor had indicated that based on the conflict that existed in prior counsel, you would understand if we were going to redepose some of the witnesses that had previously been deposed by prior counsel. There are three such.
Hold on. I believe I said if you needed to raise the issue, you certainly could, but
We'd like to
do
raise
not
the issue.
accept that as a blank permission to redepose.
We didn't, Judge. We didn't.
Okay, go ahead.
So we've been working to schedule depositions with the state, and for this morning, for the first time, we learned that they do object to us redeposing 3 of the state's witnesses. One would be Chris Corbett, the second would be Special Agent Patrick Sanford, and the third, Robert Adelson. Mr. Adelson is the son of Mrs. Adelson, of course. His deposition would not be lengthy, but we do need to redepose him. The depth of the conflict between Mr. Rashbaum representing Charlie Adelson and Donna Adelson is probably much deeper than the court understands, and to the extent you'd like to know further why we would like to depose these witnesses and that particular conflict, we'd like to be heard ex parte and in camera with Ms. Adelson present to provide some information to the court as well on some attorney-client privilege information.
All right, this is going to need to be memorialized to the extent that you can in a motion. As far as any hearing that would occur in camera, I will make a decision on that. But first, I actually need to read the basis of what you're seeking and why.
Thank you, Judge.
With respect to Chris Corbett, Your Honor, we haven't even received Sergeant Corbett's completed revised presentation. That is what the defense intends to take his deposition concerning. We've been told that we will have that presentation by this discovery cutoff, and so we were actually going to have to file a motion to extend the discovery cutoff for purposes of taking his deposition. And that was tentatively scheduled for May 14th, being that that would give us approximately 2 weeks to review the revised presentation. That's the reason for Mr. Corbett's. That's not a conflict issue, but we can certainly memorialize that in a written motion if that's what Your Honor would prefer.
Just going back and looking at the dates and the different cutoffs. 4:30 is the discovery cutoff by order right now. Ms. Dugan, as to providing Sergeant Corbett's presentation, why is this going to be so lengthy?
He's just working on the cases that are in front of him right now, but he has assured me that he's going to be working on this presentation as soon as he possibly can. I don't know of any new information in the presentation than what's already been given to him. It's more of formatting and making it look better as opposed to anything substantive. And my memory, if it serves me correctly, is that prior defense counsel's deposition of him was done after the same, as far as them getting the copy of what we were going to use, as far as everything substantive we were possibly going to use is in there. But, you know, the final result might look better at trial and be formatted in a different way. But substantively, it was all there. We certainly, and we want to be reasonable. We do object to, as far as all of these witnesses, they sent us about 24 hours they need to depose several witnesses. We worked with them to get times that we are available, and we'll continue to do that. Some of the witnesses have never been deposed before. We obviously have no objection to that. Some of the witnesses have been deposed by prior counsel of other co-defendants.
To get what they wanted. They had a job to get.
Let's go back. Let's Wendy tell us the story all over again.
You may be seated.
Ma'am, please say and spell your name.
Wendy Adelson, Wendiadelson.
Where are you from, Ms. Adelson?
I'm originally from Coral Springs, Florida.
And where do you live now?
I currently live in Miami.
How are you employed?
Now kind of part-time. I do asylum work and I fundraise for nonprofit organizations.
Are you an attorney?
By training, yes.
Okay. How long have you been a member of the Florida Bar?
Since I graduated and took the bar in 2006.
And are you here today pursuant to a subpoena?
Yes, ma'am.
All right. And that subpoena confers...
What is that supposed to mean? Are you an attorney? By training, yes. Just by training. Long time ago, I was trained to be an attorney, but I'm not that now. I'm part-time... What was it? Some asylum work. Man, if ever there was a woman that you don't give the keys to the nut house, can you imagine what she would do? I don't even want to think about it.
Use and derivative use immunity too, so nothing you say could be used against you in the future.
That is correct.
Okay. That doesn't mean you have full immunity from prosecution, but nothing you say here and nothing derived from it could be used in that prosecution. Is that your understanding?
That is my understanding.
That is my understanding. What was that line from Donna's motion? Lie in dark on bunk until lunch served. There was another layer. What was it? Lie in bunk, dark room. Lunch until.
Did you know Daniel Markell?
Yes.
How did you know him?
We were married.
When did you meet Mr. Markell?
We met in the fall of my second year of law school, so fall of 2004.
And where did you meet?
We met in Washington, D.C. He was working there, and I was looking into a summer job in Washington.
And when did you get married?
In February of 2006.
And when did you live here in Tallahassee?
We lived in Tallahassee my third year of law school, so from August of 2005 until I think around maybe May or June of 2006. And then we moved to Miami.
So like 6 months.
For a year because Danny was interested in working at the University of Miami. Mm-hmm. He did not get the job at University of Miami, and so we moved back here.
Yeah. Dan didn't get the job. No, he was abrasive. He was too abrasive in the interview. He rubbed people the wrong way. That's Dan.
In 2007, and lived here until 2014.
And where were the two of you employed during the time you lived here in Tallahassee?
I was employed at the FSU Center for Human Rights, and Danny was employed at FSU Law School.
Were you both professors at FSU College of Law?
Yes.
And were you living on Trescott Drive at that time?
When we were married, we lived, I think we rented a house before that, but at some point, maybe in 2008, we moved to Trescott Drive.
And is that the home that he was still living in at the time that he was killed?
That is correct.
Okay, and you were no longer living there, is that correct?
I was no longer living there.
All right, at the time he was killed, you two had children together, yes?
Yes.
And how many children did you have?
We have 2 children.
And what are their ages now?
They are 13 and 14.
What about at the time of their dad's death?
Getting big. Yeah, starting to, ask questions. Starting to piece things together, 13 and 14, yeah. No, they talk between themselves a lot. Like they're trying to work something out.
At the time of their dad's death, they were 4 and 3.
When did you separate from Professor Markel?
In the fall of 2012.
Whose decision was it to separate?
It was my decision.
And was part of the reason for the separation the two of you having differing views on how to raise your kids as far as within the Jewish faith?
I mean, it was a small part, but it was part of it.
Okay, that seemed to be something that came up a lot in your communication, so that's why I asked about it. What was the difference of opinion on that?
I mean, when we first met and started dating, Danny wasn't as observant or as religious as he became over time. And so the difference in our perspective on raising kids was about dietary choices and attendance at synagogue, things like that.
So in general, he wanted to raise the children more strictly in terms of the faith than you.
That is correct.
Did you...
Yeah, before we got married, he would only eat cheeseburgers. Big cheeseburger man.
Move out of the marital home while Mr. Markel was away on a business trip?
I did, yes.
All right. And did he know that you were moving out when he left for the business trip?
No, he did not.
Where did you go when you left the marital home?
I rented a home in Tallahassee.
Where was that? Do you remember the address?
Aqua Ridge Way.
3303 sound right?
That's right.
Okay. And what was the custody arrangement once you moved out of the marital home?
I mean, in the beginning, until we had a formal custody arrangement, we were just finding ways to share custody. I remember that first weekend his parents came, so I made sure he had the children all weekend while his parents were visiting from Canada. But eventually we had a 50-50 shared custody arrangement.
All right, and do you remember exactly what that looked like? Was it week on, week off, or something more complicated?
It was something more complicated. In the summertime, it was week on, week off. During the weeks, it was I think what they called like a 2-2 split, with Wednesday night being an overnight and then the weekends being every other weekend.
All right, but roughly 50-50.
50-50, but that was the split.
Okay. And I want to show you what's been introduced into evidence, State's Exhibit 56. I know you've had a chance to take a look at this before, but if you'll just kind of thumb through it and tell me if you recognize it.
Sure.
This is 3303 Aqua Ridge Way.
Do you recognize the exhibit?
I do.
Is it a fair and accurate copy of your divorce file?
It looks like it, yes.
All right. And is it fair to say this was a contentious litigation process that you had with your ex?
It was.
And I want to ask you about a specific filing in there. It's on begins on page 43. And it's in reference to a filing on January 14th of 2013 where you were looking to relocate with the minor children. Do you recall that particular filing?
I recall the filing. You said 43. I'm not sure I'm... Oh, okay.
Yes, ma'am. Yes. On the bottom, there should be page numbers for you.
Yes. Yes, I recognize it.
Okay, and that's the filing in reference to your motion for relocation?
Yes.
Okay, and did you file this motion with the intent to not be successful?
I'm sorry, I
It's
don't
been
understand the question.
suggested that you never thought that was going to be successful. Did you?
I
Or
think
not?
I thought there was a small chance that it would be successful, but not very likely, no.
Okay. And weren't you thinking, well, maybe Danny would be happy working somewhere else because he's mentioned applying elsewhere, so maybe he'll allow the relocation? Were you
Well,
thinking
he
that?
and I talked about the relocation. So when we talked about it, he thought, well, if I can live nearby in Miami, that might work, and then I could commute to FSU. I didn't mean for him to leave FSU, but he wanted to leave FSU at some point, so that
So
was just a matter of time.
So you thought it might be successful?
Sure, I mean, I thought it was possible, but not likely.
All right. And page 46 of that document, paragraph E references the job offer. The wife also desires to relocate to South Florida in order to provide a better quality of life for the children by increasing their access to close family and providing more stability and consistency. Who is the close family in South Florida?
Yeah, consistency. Consistency. Yeah, definitely. We want to be consistent. How about they're with me and my family 100% of the time. We change their names, for consistency. And you are no longer part of our lives. How about that? Can we do that for consistency?
The close family would have been my mom and my dad and my brother.
And which brother is that?
My brother that's here today.
Charlie Adelson?
That's correct.
Okay. What's your mom's name?
My mom's name is Donna.
My brother that's here today. My golden brother. Oh, Ben and Lincoln want him to come home. Their golden uncle.
Adelson?
Yes, that's her name.
What about your dad?
My dad's name is Harvey.
And where did Donna and Harvey live back in the time frame between 2012 and 2016?
They lived at the home I grew up in Coral Springs.
And how far do they live away from you currently as we sit here today?
Currently, depends on Miami traffic, but anywhere between 15 minutes and an hour.
Right. And what kind of a relationship do you have with your parents as we sit here today?
I have a good relationship with my parents.
And has that always been the case?
I would say so.
Can you describe the relationship that your mom has with your boys?
I think it's very loving. I think she's a very dedicated grandmother.
She spends a lot of time with them, doesn't she?
She does, yeah.
And when they were little and you first moved there after Danny's death, how much time was she spending with them?
When I moved there after Danny's death in 2014.
How much time was your mom spending with the boys?
I mean, we were all living together at that point. So, we were spending every day together.
How were your parents employed? Are they retired now?
They're retired now.
What are they retired from?
My dad was a dentist, and my mom used to coordinate, kind of be like an office administrator at his practice.
And did she write the checks at the practice, paychecks?
Yes. Mm-hmm. She handled all the bookkeeping.
What was the name of the practice?
The name changed over the years, but probably the name when they retired was the Adelson Institute.
And were your parents wealthy at the time that
The Adelson Institute. They're really sensitive about that, aren't they? Charlie, when he was testifying, was like, oh, because I became part of the business, I thought, hey, let's give it a fancy name. Why not? They really like to explain that, hey, look, we're not pompous, okay? We're definitely not pompous. We work at the Adelson Institute. And it really is pompous, isn't it? What are we going to call it?
your husband was murdered?
I mean, my parents worked their whole lives to support us, right? Mm-hmm. So I think the business did well for a period of time.
About $2 million in profit each year between 2013 and 2016, sound right?
They never talked to me about money, so I have no idea how much the business made at any given point.
Did you discuss your marital problems with your mom?
Well, probably enough, though, yeah. I mean, you knew what their lifestyle was like.
At all?
I did, yeah.
Okay. What about the resulting legal issues? Was your mom read in on those things?
Look at this fox. A fox bear. A courtroom fox bear.
I mean, I definitely updated her about the results of the relocation when that petition got denied, but not kind of the ins and outs of every part of our divorce.
What about your dad? Was he invested in your divorce status?
I think the same as my mom, just worried about me and worried about the boys.
Mm-hmm. What about your brother? Did he take an interest in the ins and outs of your divorce?
No, not really.
Did he need to protect you from Dan Markel?
No, I mean, I don't think I need protection.
Were you physically in danger from Dan Markel?
No, I wasn't in danger.
Did the litigation revolving around the divorce and the subsequent issues that arose, did that impact your family back in South Florida?
I mean, only to the extent.
Yeah, only to the extent of, like, $500,000. Yeah, my attorneys, there was $600 an hour. They worked a lot on the case.
That I think they felt bad for what I was going through, but
I want to show you an exhibit that I've marked as State's Exhibit 59. Sorry, 57, Your Honor. I've seen this one before as well. Does that one look familiar?
I don't remember it, to be honest. It's from 10 years ago.
Take a moment to look through
10
it.
years.
Sure.
When you're done, I'll let opposing counsel take a look at it, but go ahead and let us.
If someone showed me an email that I wrote 10 years ago, I would remember it, Especially if it was like a legal fucking situation. I mean, yeah. I'd probably be able to remember where I was when I wrote it. It would stay in your mind. Wow, it's so 10 years ago.
Know when you're done reviewing it. Are those emails between you and your mother?
I don't think I responded. I think they're just emails from my mom to me. No?
Okay. Mostly all from your mom?
Yeah.
Okay, and the email address says, I think it's something like Wendy Harvey. Can you tell from the content that it's your mom typing rather than your dad?
Yeah, the email's Donna Harvey, my two parents.
The fact that Wendy never replied to these emails, right, shows me that that was all part of her setting this whole thing up. The crazy emails that we read out all of them the other day. Wendy didn't respond to any of them. Just let Donna keep leaving that evidence, that written evidence, that written digital footprint evidence of your pathological hatred and, you know, need to crush Markel like a walnut. She set that whole thing up. Tricked her mother, like mind control. Write the emails. Put all of your confession in your emails that I will not respond to or incriminate myself in any way. We're doing you today, Mom. We're incriminating you. Write the emails.
Names, so they've been married over 50 years, so they have a joint email address. So it's from both of them.
Okay, so what I want to draw your attention to is page 2 of that exhibit, that first paragraph there above the word response. Did you have an opportunity to read that?
I read it real fast, but
scanned.
I can read it.
And what I want to draw your attention to is specifically the part that reads, your father has made numerous trips by plane for weekends and changing the patient's schedules around so he can continue to spend significant time with the children. Did you?
Are you objecting, Mr. Rauschenberg?
I just didn't hear it get admitted into evidence.
Judge, at this time I'd ask to move this exhibit into evidence. Which number I've already brought.
No objection.
It's 57.
57.
Thank you. So that paragraph, isn't that paragraph going into detail about how the issues surrounding your divorce and litigation is financially impacting in a negative way your parents' business?
That's what my mom...
Yeah, here, your mother. She's complaining in a vicious style about how much this is costing.
Says here, yes.
Okay, and it also says, additionally, this loss of income affects my family because my older brother, also a dentist, purchased the practice from my father in mid-July 2012. He has a monthly payment to make to my father based on the sale of the practice. It isn't fair to him to have decreasing monthly income statements from the practice due to my parents spending so much time.
Yeah, his monthly income statements, they went down from 250,000 to 235,000. It's not fair on him.
Here in Tallahassee. So this is an argument that your mom is proposing, right, to help you, give you an idea of what might persuade the courts to allow the relocation. Do you agree with that?
Yes, that's what she was doing, yes.
Okay, and she's indicating that both your parents as well as your brother have suffered financially as a result of you not being able to relocate.
Yes.
Okay. And on page... Do you have page numbers in the bottom right corner of your exhibit?
I have them in the top so I can see.
Okay, so 5 of... Well, let me look. Give me a moment. So it'll be the second email in your packet, page 1 of 3.
Okay.
Do you see that?
I see that page.
Okay, and there's a rest of your life highlighted or underlined in the center and in bold. Do you see that?
Yes.
Okay, right before that, it reads, however, the rest of your life and consequently Dad's, mine, and yes, even Charlie's will be affected by how well you can perform/act before July 31st. You need to be a good actress you can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet. Who's Jibbers?
Jibbers, she's referring to Danny.
And was Jibbers a name he went by or just something you called him behind his back?
Jibbers was a silly nickname that I gave him during the divorce proceedings when he was being pretty scary and threatening, and it kind of made me feel less scared of him.
Okay, so not something you called him to his face.
No.
Yeah.
But that was a word that was only used to describe him.
When he was being scary and threatening, I would call him my fuzzy wuzzy jib jab jubby bubby. And it just, it made him seem like a cuddly doll. My fuzzy wuzzy jib jab jubby buddy.
Yes, it was a nickname.
Okay. So in this, again, your mom is referencing how everyone's life is being affected by this relocation, including your brother, Charlie. Do you agree with that?
That is what she said, yes.
All right. Is your mom overprotective of you?
Yes.
All right. And is it fair to say she's, a little on the controlling side?
I don't think she's controlling, but she's definitely overprotective.
Did she ever try to micromanage your life?
Maybe, yeah.
Did she have an interest in who you were dating and who you weren't dating and who you should be dating when you were single?
I think she was usually disappointed that I wasn't dating more.
Okay. For example, isn't it true that she would not let you drive to and from Tallahassee to South Florida?
Well, I used to drive before I had the boys, but they were young and she preferred to come with me and give me some extra support.
So what would that look like if you were going to take a trip to South Florida? Would they come up here and get you, or?
No, sometimes I would go myself with the kids, but I was breastfeeding both of them, so it usually looked like me breastfeeding a child while I entertained the other in the Okahumpka.
Sometimes I would have to breastfeed each of them at the same time. Driving with a child on each breast at the Humpka, what was it? Rest stop.
Rest stop. So
okay.
it was a lot. It was helpful to have some backup.
All right. And so that time frame you'd be referencing is like the 2013 time frame? Because not around the time of Danny's death you wouldn't have still been breastfeeding, would you?
If Lincoln was 3, no, I would have stopped maybe the year before.
Okay.
So maybe 2012, 2013.
Okay. And wasn't it true that around the time of the death they were still doing this practice where they would prefer to drive you to and from South Florida?
I mean, not every time, but sometimes.
Okay. And would your mom sometimes enlist your brother Charlie to convince you to do certain things in your personal life?
Can't really think of an example of that.
Well, dating Dave was a big one on some of the materials I had.
Yeah, people like Dave.
All right, and your mom really liked Dave.
Yeah, everyone liked Dave, but we were just friends.
Okay. Did she try?
What is Charlie's fucking expression now? Is he remembering Dave? Oh god.
Do materials I had.
Yeah, people like Dave.
He's always going on about Dave, isn't he? Like that his nephews farted on him, and Dave thought it was funny, and Charlie was really impressed that he wasn't like grossed out or something. He tells that story at least 5 times during this trial.
All right, and your mom really liked Dave.
Yeah, everyone liked Dave, but we were just friends.
Okay. Did she try? So she would try to get Charlie to convince you to date a certain person.
I don't think she was getting Charlie to convince me to date Dave. I think everyone liked Dave.
Oh, so that's it. Charlie's trying to look like that it's ridiculous, this theory that George is coming out with.
All right, and would she try to get Charlie to convince you to...
They got nothing. They're reaching. They got nothing. They're just making stuff up.
Do certain things as far as your professional life, what jobs to take.
No, I don't think so.
Hey, Jackie. Thanks so much for the coffee, Jackie. Great way to support the channel, guys. Head over to buymeacoffee.com/True Crime Metrix to support the channel. To support the channel and help us grow. Help us grow. Help us change. Help us improve. What can we improve? Well, how about more regular programming? That'll be good. I did have an alarm set last night, but I just went to get one more half hour. I looked at the phone, and it said 8%. And I thought, I better go and plug that in before I go back to sleep for half an hour. And I thought, no, it'll probably last. But it didn't. And we stayed asleep all night.
Did you try to get Charlie to do certain things like advise you on investment decisions, whether or not you were going to buy a house, for example?
I don't think so. I don't remember that. Danny and I made that decision together.
Once you had left.
Thanks, Amy, for the super sticker. And we don't even have a goal. No goal tonight. Doesn't matter.
Dan, and you were living separate.
Better finish up this trial. Yeah, the defense only called one witness, it looks like. The grandmother. And then to a closing argument. So we've got to wrap that up. Should we do day 3? And what I was thinking of doing was skipping day 3 and going straight over to the grandmother and then closing argument and then the verdict, right? And then maybe come back to day 3 if necessary. But I think it's just more cops. You know, day 2 was pretty like, it was quite kind of long, wasn't it? It was just cops saying stuff.
Did you look into purchasing a home here in Tallahassee?
I did, yeah.
And did your brother Charlie convince you not?
Oh yeah, but then after we've finished, we're gonna have to head over to what is it called? The defense rests for a discussion about what the fuck. Why do you think he's innocent? Look at him.
To do that.
I don't remember him convincing me not to. The only reason why I didn't was because I was waiting on the money from Danny from the settlement and he didn't pay it, so I couldn't afford the house.
And your mom didn't want you to buy the house, did she?
That's not true. My parents were looking to buy a house in Tallahassee as well.
Okay. Did you have...
Yeah. Well, where is any evidence to back that up? My parents were looking to buy a house in Tallahassee as well. Well, I don't believe you. They hate it. They hate Tallahassee.
Strike. Generally speaking, does your mom manipulate the personal lives of her children?
No.
Is your mom, like, if she's really upset about something or worked up about something, is that something that your brother Charlie's going to hear a lot about? Who's going to hear more of it, you or Charlie?
Well, if my mom's upset with me, probably Charlie. And if she's upset with Charlie, probably me.
Okay, so do you get a lot of that? Do you hear a lot about... Let's go back. Let's go to before the murder. Did you get a lot of Donna just giving you an earful about what Charlie needs to be doing?
Probably, at some point.
What was Charlie doing with his personal life? What did his personal life look like?
At what point?
Before the murder.
I mean, at what period of time before?
All of them. Wasn't it just a revolving door of girlfriends?
Right, but my mom didn't complain to me about that.
She didn't mind that with him.
I don't understand the question.
She didn't mind if he went from girl to girl to girl. That was acceptable.
She didn't really weigh in on it, no.
Who talked to her more, you or Charlie?
Charlie.
A lot more, right?
Yeah.
At the time of Dan Markel's murder, were your parents extremely angry with Dan?
At that point, no. They were in a much better place.
I want to direct your attention to an interview that was conducted on, I think this was your law enforcement interview. So July 18th, 2014. And I'm specifically for court and counsel looking at page 27, lines 11 and 12. And I've got it open to the page, but you can flip around if you need to familiarize yourself.
Sure.
And I'll take that exhibit if you want.
Do you want me to flip through or just look at this one page?
If you'll just look at that one page, well, I mean, not that reminder. 27. Let me get to where you are. So page 27 there, lines 11 and 12, and I've got it highlighted for you.
Yes,
Says, Ms. Adelson, my parents are, very angry toward him. Is that true?
Was that
Isn't
true?
that what you said? Your parents were very angry toward Dan.
Can I read the rest of the sentence?
Sure.
So I say, my parents are very angry towards him, but even when they're around my kids, they would never say a bad word about my kid's father.
And then on page 288, line 24 through page 289, line 1, and that's going to be, Didn't you say, it's like my parents have more reason to dislike Danny than almost anyone else? Is that what you said?
That is what I said.
And that's because he hurt you, right?
And I was saying that in the context of talking to law enforcement for hours and hours and trying to help them figure out who might be responsible.
Right. And who did you tell them might be responsible?
Well, I told them many, many people. But are you asking about this particular moment right here?
You told them your family might be responsible.
Or potentially someone to do with a former student or his current girlfriend. I mentioned lots of people that I thought could be responsible.
Okay. And of the lots of people that could have been responsible, your family was one of them.
Yep.
Because they might have done this thinking it would help you. I mean, that's what happened, right?
I'm sorry, I don't understand the question.
Your family had your ex-husband killed to try to help you, didn't they?
No, that's completely untrue.
And back to the divorce, the petition where Danny is responding to your petition for the motion to relocate. Are you familiar with that filing, or do you need to take a look at it?
I need to take a look at it.
All right, it's going to be page 79 through 101, and this is back to our exhibit 56.
22 pages.
And again, that was the filing begins on page 79. I'm specifically interested in 82. And in this filing, doesn't Mr. Markell say, quote, the husband affirmatively alleges that the wife helped herself to non-marital assets, including money and stocks owned prior to marriage, as well as numerous personal non-marital belongings of the husband, such as luggage, bicycle, tennis racket, and family heirlooms. The wife has refused to return these items or to allow the husband into her home to see what other personal belongings were taken without his permission or acquiescence.
Yeah, he made all that up. Yeah. He was a jilted lover. And he made all that up.
So my point is, he's accusing you of theft. in this paragraph.
Those are the words that are here, yes.
Yeah, and he's very adamantly objecting to your relocation, right? On page 82, it says the sole stated reason the wife seeks to relocate is so that she can be closer to her parents. Was being near your parents the sole reason that you wanted to relocate?
No.
It wasn't the sole reason stated in your petition?
It wasn't the sole reason stated in my petition, and it wasn't the sole reason that he and I talked about before I filed the motion to relocate.
Why was he so adamant and so confident that this was the real reason you wanted to be down there?
I think there's a lot of things in these pleadings that are not true, so just because it says something doesn't make it true.
Sure, but did he know that your mom was just grinding on this issue of trying to get you down there?
He would have had no idea.
He wouldn't have been, that wouldn't have been known to him?
I don't think so.
But he was accusing you in these pleadings of all kind of stuff, right? I mean, I'm not saying it's true, but hiding financial assets, failing to disclose things, kidnapping his kids in the middle of, his business trip, all those sorts of things, right?
Yes, he said lots of things.
All right, and you said a lot of things too. There's filings going both ways that are pretty venomous. Would you agree with that?
I would not agree with that.
Yours were pleasant.
I'm not saying divorce filings are pleasant, but mine were not venomous.
Okay. Did your mother, Donna Adelson, review the filing in which Dan Markella is accusing you of this theft and all that?
My filings, they weren't venomous at all, okay? Venomous is like a dangerous snake. And that's not me. Imagine what it would be like for an angel to get a divorce and how they would act within those proceedings. That's me. That's what I would do.
The stuff.
I don't remember if she did.
What about the one where Dan Markell is asking that your mother not be permitted to have unsupervised visitation with the kids?
My mom never saw that because after he filed that, he then asked my parents to babysit the kids. And my mom baked him banana bread, gave him a hug goodbye. So there was nothing truthful about that pleading that he filed, and my mom never saw it.
Yeah, we can skip to that. Amy requests to play Charlie Adelson's Arthur hearing, which is what Donna will be having on the 26th, is it? I think there's another case management on the 25th. Happy birthday, George Harrison. And then the Arthur hearing on the 26th, which they've booked out 3 hours for in the courtroom. That's the time slot. So that should be good.
The Honorable Robert Miller presiding.
Good morning. Please be seated.
Judge Whelan. There's only one ear.
All right. Good morning to everyone. We are here this morning in the state of Florida versus Charles Adelson, 2016 CF 3036. And let's see, we have Ms. Kappelman and Ms. Dugan on behalf of the state, and Mr. Roshbaum and Ms. Myers on behalf of Mr. Adelson, who is here in the courtroom. All right. Good morning to everyone. Okay, we're here this morning on the defendant's motion for pretrial release and request for Arthur hearing. We have some people I know that are listening in by Zoom. Ms. Kappelman, we have that all taken care of?
I think so, Judge.
Okay, great. And so they won't be participating, but they're just listening in. And anything that we need to address before we get to the testimony? I'll go to the state first. Ms. Kappelman?
No, sir.
Anything for the defense?
No, Your Honor.
Okay. I think we're all familiar with the...
So I think what an Arthur hearing is for a serious crime, capital crime, in a state in Florida where there is no bond available, every defendant can request special circumstances and considerations about their pre-trial release. And that's called an Arthur hearing. I think that's what it is.
Standard here. I've reviewed the motion. I'm familiar with the case, and so I think we'll move right to testimony. And so it's the state's burden. Ms. Kappelman, how many witnesses will you be calling today?
No witnesses, Judge, just argument and exhibits.
Okay. Do you want to offer your exhibits into evidence first before your argument?
I was going to I have a PowerPoint presentation. I was going to kind of admit them as I go along.
All right. We can do that. If you have any objection, then...
Sorry to interrupt you. You should have an exhibit list before you...
Okay, I do have that. And then, so I know if you have a PowerPoint, if there's any objection at any time, then we'll stop the PowerPoint and then take care of that at that time.
Thank you, Your Honor. Is Your Honor able to observe the PowerPoint on your screen?
Well, I was, but it just went off. Now I can see it, yeah.
Okay. As Your Honor mentioned, we are all familiar with the Arthur hearing standard of proof of guilt is evident or the presumption is great. Obviously, we start with this man, Professor Dan Markell. We've had 2 trials related to the murder of Professor Markell. His family has also prepared a statement for your consideration, which I would like to read at the conclusion of this presentation. The investigation into his life and death revealed that his ex-wife and former in-laws had a strong motive to kill him in order to resolve a messy custody and relocation dispute over his...
So Georgia's going to go through the wealth of evidence that they have against Charlie here. And this is what we can expect to hear in a couple of weeks from Donna. Well, about Donna. In her own Arthur hearing. The state's going to lay it out. They're going to have to lay it out to the court on record. And it's going to be like this, the evidence, but different, right? Donna evidence. Oh. Should be nice.
His 2 sons. On July 18th, 2014, now over 8 years ago, Professor Dan Markell was gunned down in the driveway of his home. He suffered 2 gunshot wounds to the head, which did not bring about his immediate death. Instead, he suffered for some 13 hours in the hospital before succumbing to his injuries. 3 people involved in the plot to murder Professor Markell have already been convicted. Luis Tato Rivera on October 4th, 2016 by a plea of no contest. Sigfredo Tudo Garcia on October 15, 2019 by conviction by a jury of his peers, and Catherine Katie Magbanua on May 27, 2022 by a second jury. I have prepared a binder containing 16 discs of the testimony from Ms. Magbanua's trial in May of this year, which Your Honor presided over. I know you're very familiar with it. But there is no transcript in existence yet of that, so I would like to offer the discs which are certified by the official court reporter as true and accurate copies of the testimony that was taken in this case as State's Exhibit A.
Any objection?
No objection, Your Honor.
Be admitted as State's Exhibit A.
And Judge, the evidence in this case showed that the link between the men that came to Tallahassee to murder Dan Markell and the family members with the motive to kill him was Catherine Magbanua, and specifically her romantic relationship with this defendant, Charles Adelson. These photos were introduced in the most recent trial to evidence that the 3 convicted killers knew each other and that one of them was intimately connected to this defendant. Dan Markell's ex-wife, Wendy Adelson, testified that her brother, the defendant in this case, repeatedly made jokes that he had looked into hiring a hitman to resolve the issues between her and her ex-husband, Dan Markell, but that buying her a TV was cheaper. She further testified that the defendant did buy her a TV as a divorce present, the same TV that she was having repaired in her home around the time that her ex-husband was being murdered. The mention of a TV would later come up again in the trial through recorded conversations between the defendant and his mother, Donna Adelson, where Donna refers to the undercover law enforcement extortion operation as a TV, indicating this TV is going to be about $5,000. Witness Jeffrey Lacoste, Wendy Adelson's boyfriend around the time of the homicide, testified that he...
Yeah, the only excuse for the TV being mentioned in connection with the undercover who handed her a picture of the man that they'd had murdered and used TV to cover up elements is that was just a random chance of opportunity. It was a complete fluke. She could have said food processor or blender, hair dryer, ironing board, anything. This ironing board is going to be about $5. Then they'd be all right. Yeah, no, a coincidence.
He also heard the joke from Wendy Adelson that her brother had looked into hiring a hitman, but that the TV was cheaper. He also testified that in a very serious subsequent conversation.
Look, I bet Acapella's gone to check the Groundhog Day rules. Listen, man. Acapella said, on Groundhog Day, Punxsutawney Phil saw his shadow, predicting 6 more weeks of winter. It's when he doesn't see his shadow. When he sees the shadow, that's an early spring.
Wendy revealed to him and confided in him that her brother really had looked into hiring a hitman to kill Dan Markell, and that was shortly before the hit was executed. Luis Rivera indicates that he was hired by Sigfredo Garcia, who was hired by Catherine Magbanua to kill Dan Markell. His understanding was that this job originated from the dentist that Catherine Magbanua was dating, that's this defendant, because his sister, Wendy Adelson, needed to get her kids back. An abundant amount of communications records are critical to this case. I want to just touch on a few highlights from the most recent trial of Catherine Magbanua, which are introduced into evidence as States A. This slide shows Catherine Magbanua's location on June 2nd, 2014, consistent with her being present at the time and location that the first rental car was rented by Sigfredo Garcia for the purpose of doing the killing. During this time frame, Catherine Magbanua made a 2-minute phone call to Charlie Adelson at 8:57 p.m. Then along her route home, she placed a second call to Charlie Adelson, which lasted 25 minutes, so about the whole time she was en route back home. And this slide here shows that the data points associated with that call. This slide shows the phone activity prior to the rental of the Prius, which was the vehicle that was ultimately used by the killers to drive to Tallahassee. Calls are observed going back and forth between Catherine Magbanua and Sigfredo Garcia, and then between Catherine Magbanua and Charlie Adelson, consistent with Magbanua as the conduit for the flow of information between the two men. The first call after the murder from either Rivera or Garcia was Sigfredo Garcia placing a call to Catherine Magbanua. Per Luis Rivera, Garcia advised Magbanua the job was done, and Magbanua replied, I know. After the murder, there's a flurry of communications between the parties. In this slide, the murder is represented as the red line. And the text messages between Magbanua and Adelson on the day of the murder, where they appear to be making plans to hang out at Charlie Adelson's house that night. The state's theory is that the purpose of this visit was for Magbanua to pick up the stapled money from Adelson, which was payment for the murder, and cuts of which would be delivered not only to Magbanua but also to Garcia and Rivera the next morning. This slide shows Catherine Magbanwa's last two calls on the day of the murder, July 18th, 2014. Both were to Charlie Adelson at 10:12 p.m. and 10:20 p.m. After these calls, her phone is consistent with being turned off until the next morning, which was the morning of the money drop. This slide shows Magbanwa's locations on the morning of the money drop, consistent with her phone coming back online in a direction of travel south, consistent with having come from Charlie Adelson's residence and traveling toward the location of the money drop. The next slide shows locations of the handsets of the parties consistent with the money drop occurring at Luis Rivera and Jessica Rodriguez's residence between 10:30 a.m. and 11 a.m. on July 19th, 2014. This slide shows Magbanwa's handset consistent with her leaving the money drop location and heading toward the home of Yendra Velasquez Mascaro to pick up her children. Mascaro testified that this was the only time she ever kept Magbanwa's
It's Velasquez.
children overnight, and that when Magbanwa picked the children up, she indicated that Charlie Adelson's brother-in-law had been involved in a car accident. June Umchinda is a witness who was one of Charlie Adelson's girlfriends subsequent to Magbanwa. Umchinda testified that it is Charlie Adelson's practice to keep his money in stapled stacks of $100 bills. And per Luis Rivera, on the day after the murder, he received stacks of $100 bills stapled into $1,000 stacks as payment for his role in the murder. That money was delivered to him by Garcia and Magbanwa the morning after the murder, and the morning after Magbanwa made plans to spend the night at the home of Charlie Adelson. The financial evidence in this case is important as well for your consideration. The evidence showed that Charlie Adelson deals in a largely cash business, that his family has a safe containing large amounts of cash, and that there is a safe in his residence containing cash as well. An analysis of Catherine Magbanwa's bank records around the time of the homicide show a striking spike in cash contemporaneous with the murder and an increase in cash deposits over the next year. Magbanwa also received breast augmentation surgery shortly after the murder, an expense that was paid for in cash, half of which was provided by the defendant per June Umchinda. The defendant, Magbanwa, received a Lexus vehicle which was previously the property of this defendant's father, Harvey Adelson, for free or at a very discounted price, as the title indicated a nominal fee was.
Acapella. Pennsylvania Dutch superstition that if a Groundhog Day emerges from its burrow on this day and sees its shadow, it will retreat to its den and winter will go on for 6 more weeks. Yeah, well, that's not how it is in the film.
Paid for the vehicle, but no financial documentation could be located to evidence the actual payment. And most importantly, financially for these purposes, the defendant put Catherine Magbanwa on the payroll.
Amy says, I still don't understand how Katie replied, I know, to Sigfredo Garcia. Well, I think that how much time had gone by? It was several hours, wasn't it? I think it was at least 2 hours. It wasn't like they called straight away. Well, you know, I think that there would be a text message from Wendy. Wendy saw the cop cars and the police crime scene tape at Trescott. She had visual confirmation before the news. Well, it was on the news pretty quick as well, though. I mean, So Wendy would have sent a text about the TV to Donna, and Donna would have sent a text to Charlie. Yeah, and Charlie was with Katie or said something to Katie.
Of his family business, beginning very shortly after the murder and continuing up until the first arrests were made in this case. Magbanua collected over $17,000 from the Adelson Institute with little to no evidence that she did anything to earn the payments. In Magbanua's most recent testimony, she could not articulate anything she did for the business other than make one appointment, or for Charlie Adelson, and said the defendant was just doing her a favor, even though they were no longer in a dating relationship. The undercover operation in this case was designed to illuminate the co-conspirators and their respective roles in the conspiracy. When the defendant's mother, Donna Adelson, was approached on the street by an undercover operative posing as a gang member who knew about her role in Dan Markel's murder and was attempting to extort $5,000 from her, she called this defendant, Charlie Adelson, and said she needed to speak to him in person as she was approached on the street by someone, and it had to do with, quote, the two of us. Donna Adelson tells Charlie Adelson that the extortionist mentioned his ex-girlfriend. And Judge, at this time I would ask to introduce State's Exhibit B for the purposes of this hearing. B is a disc containing the wire calls that were introduced into evidence in the most recent trial. The wire calls are certified by the clerk of court as a true and accurate copy of the exhibit that was introduced into evidence.
Any objection?
No objection, Your Honor.
Be admitted as State's Exhibit B.
And although there were many ex-girlfriends to choose from, this defendant called only one ex-girlfriend, Catherine Magbanua, whereby a very revealing string of conversations is had over several days captured in State's Exhibit B for purposes of this hearing, demonstrating the flow of communications to always occur between the co-conspirators in this particular pattern. After the undercover operation, or the bump as it is commonly referred to, Charlie Adelson and Donna Adelson meet to discuss the issue in private.
If Katie McBarwab pops out of a hole and is frightened back in by the shadow of her augmented breasts, does she get 6 more years added to her sentence?
Followed by Charlie Adelson's recorded meeting with Catherine Magbanua in the Dolce Vita restaurant, whereby he can be heard making several incriminating statements to her about the interaction between the undercover officer and his mother. And at this time, Judge, I would ask to move into evidence the recording from the Dolce Vita restaurant, which was introduced into evidence in the previous trial, also certified by the clerk as a true and accurate copy of that exhibit as State's Exhibit C.
Any objection?
No objection, Your Honor.
Be admitted
We should
as
do this. We've got a clear... Should we do this one? We've got a clear video of that. Amy, where's the link for that?
State's Exhibit C.
And some of the statements that the defendant made that I'd like to highlight for Your Honor that were captured in this exhibit are, quote, if they had any evidence, we would have already gone to the airport. The problem is, even if they bug this, even if they bug your home phone, nobody is going to, and then it's unintelligible. You've got to understand, in order to prove it, you have to put that person at the scene at the time, not in the car. Because the fact is...
Where did he get that theory? I mean, and that's just so... it's just wrong. In order for you to be charged, you have to actually be there. Like, if you just paid someone to do it and weren't there, they can't charge you. Fuck.
It's like, even if, let's say you just sat in the car, right? And then I go ahead and I commit a crime. And then I go, but your DNA is...
Like, is he just trying to convince Katie of that, or does he believe that himself?
...in the car. And I go, yeah, Katie was in my car. And she got out and she did this horrible...
Amy, the link for the Dolce Vita video. I think it was on the same channel that the Luis Rivera Proffa was a
crime. Okay, so they come and get the DNA in the car and go, oh, Katie was in the car. No, Katie sat in the car for 2 minutes, and they got in the AC, and then they got out of the car. Katie has
they come round and they say, oh, Katie was in the car. And you say, no, Katie sat in the car for 2 minutes. Yes, she hired the car, sat in it for 2 minutes, lent it to a friend. And they took it to Orlando and robbed Burger King.
Nothing to do with me robbing the Burger King. So even if I can prove that, yeah, Katie was with me, can you put Katie at the Burger King? I can say that she sat in the car, yeah. So discussing the quality and implications of the potential evidence in the case. Later, he says, let me ask you a question. When everybody was there the next day, did any of you take any money? It's not like you're driving around in a Bentley, cruising around in a mega yacht, referencing the money drop, wanting to know if there's anything flashy going on with the money that could draw attention to them. Later, he says, so if you didn't witness it, you only heard a rumor on the street that this person did something. Do you know what that's worth? 0. Then what you do is you wear a wire. You get this person talking, and if you can get the person to confess on wires, then you have something that you're charging. You have a confession. You have an admission of guilt. So discussing the bump as a possible law enforcement undercover operation, whereby somebody wearing a wire is trying to get information that could be used against them in the case. What if you rented a car today? I go, Katie, can I borrow it for the weekend? And I'll bring it back on Tuesday. You go, yeah, sure. So you rented a car, you've been in that car, I drive it to effing Orlando, I rob a McDonald's in Orlando, I come back and I go, here's the keys, Katie, and you go, okay, thanks. Yeah, you rented it, but, or what if you were effing out all weekend and you didn't even know I took your car and I did something and I brought it back, okay? My point is, I don't have any knowledge of what went on. Evidently, this person either is pretending to or does. I don't want someone paying visits to my parents. A few lines down, and I think if they thought I had something to do with it, they would find me and talk to me. You know what I'm saying? Like, talk to the person who's involved, not fucking...
Yeah, why are they not talking to me, you know? I mean, talk to the person who's involved. What a thing to have on tape. Talk to the guy with the blood on his hands.
People who aren't involved, and I'm not involved, but if they knew our relationship, your relationship is with me, not my family. Later, the discussion of if this is a person that does have information about the murder that has approached his mother. Defendant says, okay, next thing you know, this person is singing. Other people start singing. As soon as they have him, he starts calling your name out. Oh, my parents are going to have to say, and there's some discussion about the guy, that his parents will have to report that the guy approached. Then I want to give them the money, but what I don't want to get involved in is next Tuesday, he's asking for $10,000. So this was my idea. I give you the money, you contact, there's some unintelligible there. Listen to what I'm saying. This is why I'm saying it. I give you the money, you talk to him on the phone. So Charles Adelson is instructing Catherine Magbanua what to do to resolve this issue of the undercover operation. This is what I want you to do. I want you to call up this person and say that I got a call from some friends of mine who says that you reached out to them and that you mentioned my name. And remember, protect your name, something about protect your name recently. So what you're going to say is, I got a call from some friends of mine who said that you had reached out and that you had mentioned my name. These people want to go to the police because they had nothing to do with what you're talking about, okay? And frankly, I don't know what you're talking about. but the name sounds familiar of who's incarcerated, so I'm going to give you something as charity to help the less fortunate. But do not contact these people again, or they're going to the police. Again, instructing Catherine McBanois on exactly what to say when she calls the undercover operative / gangster that's approached his mother. That way he gets his money. He also knows...
Yeah. These people don't know what you're talking about. They want to go to the police. And frankly, I don't know what you're talking about. But the name sounds familiar. So I'm going to give you something as charity to help the less fortunate. Can you imagine anyone saying that, let alone Catherine McBanois? What a stupid thing to say. And that's his big move? To, like, not make an incriminating statement? Don't show any consciousness of guilt. The name sounds familiar, so I'm going to give you something as charity to help the less fortunate. But don't contact these people again or they're going to the police.
That you know everything, that you may have a friend who may not be so cool with what's going on too, who may know people, who knows how to handle people like this, and that this is a effing one-time thing. This is charity to help somebody out. If it's this guy, maybe in the back of he knows something times a million. And now he's effing with his wife, and he's effing with him, and you F with something, you F with the king himself. You better kill him, because he's going to be a big problem, and he knows who you are. If he can't do it, he'll have someone else do it. And so help me God, if they fuck with my family, it's going to be like effing that Nazi shit. Because this will be done. You know what I'm saying? I mean, Katie, I don't care what I spend, okay? I swear to God. Later he says, like, you know it. I don't have to sit here and tell you what I would do. I would show you what I could do. You know what I'm saying? Like, you know how I am. Like, I look for things to do. You don't ask me for shit. I'm the one that's like, hey, somebody's birthday's coming up. I got you. And I'm the one who's like, hey, I'll sell you a Lexus for a very good price. You know what I'm saying? Like, I don't have to tell you, I show you. There's a difference. Referring to the favors and financial benefits that he gives Catherine McBanois. Later, Charles Adelson says to Catherine McBanois in this conversation, listen, you giving some money is not an admission of any kind of guilt.
Yeah, you giving some money is not an admission of any kind of guilt, but still, I think you should be the one to do it. I just don't think I'm gonna... It's a role for you, Katie, but it's no admission of guilt, so don't worry.
Later, there is a third meeting between some of the parties. This one is Charlie Adelson and Harvey Adelson. They meet at a Matsuri, which is a sushi restaurant, on April 21st, 2016. This is an item which has not been previously introduced into evidence. It has been provided in discovery. And at this time, I'd ask to introduce a copy of this statement, which I've marked as Exhibit D on a disc.
Any objection?
No objection, Your Honor.
Be admitted as Exhibit D.
And this is relatively short, but I'd like to publish it for Your Honor.
All right. So you're going to play the audio?
Yes, sir.
Okay.
Hopefully you'll be able to hear it. There are captions as well.
But are the captions admitted as evidence? Or is it opinion? Should we have another coffee? I think we should have another coffee. This is like the biggest piece of evidence against Harvey Adelson, isn't it? And Katie's agreed. Dad, all day long, it's not done like that, Dad. Like, what's the innocent version of what he's referring to? TV repairs aren't $5,000, Dad. Katie is looking into it. She's looking for a TV repair guy right now. I didn't think they were that smart. Hang on, was he talking about the police or the Latino gang members? When Harvey said, I didn't think they were that smart, was he talking about the cops or the gang members?
One second. Cooperate, why would you not? Like, because it's the attitude of, I'll pay to make it go away, but it's utter nonsense.
Utter nonsense. They're savages. They're savages. The working class. It's utter nonsense. The whole thing. It's not done like that. They're not civilized. They're not civilized. Why wouldn't they want to talk to Wendy, Neverly Darling asked? I think because there was just an agreement that Wendy will never be brought in, we'll say the least.
At this time, I'd ask to introduce a statement that was prepared by the Markell family as State's Exhibit E.
All right, any objection?
No objection, Your Honor.
Be admitted as State's Exhibit E.
And Judge, before I move on from that, one additional statement that I failed to bring to your attention from the Dolce Vita recording, State's Exhibit C, is where Mr. Adelson indicates, there's a discussion of every Tom, Dick, and Harry is going to show up and want assistance if they pay out the money to this thug that's approached his mother. And there's a comment in which Mr. Adelson says, hey, you know who this is coming from? The inside. Right, and State's Exhibit E is a statement prepared on behalf.
This is coming from the inside, where we are, Katie. Whoever did this.
Of the Markel family by their attorneys in conjunction with them, and it reads, Dear Judge Wheeler, we represent the family of Dan Markel, his mother Ruth, his father Phil, and his sister Shelley. On behalf of the Markel family and pursuant to their legal rights as crime victims under Florida law, we respectfully submit this letter to oppose defendant Charles Adelson's motion for pretrial release. And there's some law cited there. More than 8 years since Dan Markel was brutally murdered outside his home, justice has only been partially served. His boys are growing up without their father, and his parents are spending their elder years in searing pain, mourning the death of their son and the loss of their beloved grandchildren. The upcoming trial of Charlie Adelson is an important step on the path to justice for Dan, his family, and the countless friends, colleagues, and loved ones who continue to mourn him around the world. And there is still far more work to be done to ensure that every person responsible for Dan's brutal murder is held accountable. In our view, if Mr. Adelson is released pending trial, there is significant risk that he would flee, attempt to corruptly influence witness testimony, otherwise tamper with trial evidence, and or conspire with or be influenced by other co-conspirators. For all these reasons, his motion for pretrial release should be denied. And there's some law stated there as well. Tellingly, Judge Hankinson twice denied similar requests for pretrial release made by Catherine Magbanoa, a convicted co-conspirator who faced the same charges for the same murder for hire, even without Mr. Adelson's substantial wealth and financial means to flee. Seriousness of the offense and weight of the evidence. On July 18, 2014, Dan Markel was shot twice in the head at point-blank range, just hours after dropping off his 2 young boys at daycare. This was not a crime of happenstance or wrong place, wrong time. It was a cold-blooded contract killing, premeditated, planned, and paid for by those who wanted Dan dead. No criminal offense could be more shocking or more serious. Dan did not die immediately. He suffered terribly in the hours after being shot, in what certainly were the most painful and terrifying final moments of life. In our opinion, the state has presented overwhelming evidence that Charlie Adelson, working with or on behalf of other members of the Adelson family, commissioned the contract killing of Dan Markel. Some of that evidence has already been presented to the jury in the trials of Sigfredo Garcia and Catherine Magbanoa, co-conspirators in Dan's murder who have been convicted of first-degree murder and conspiracy to commit murder. The conviction of Ms. Magbanoa, Charlie Adelson's former girlfriend, was based on evidence beyond a reasonable doubt.
How do you think Dan Rashbaum is feeling right now at this moment in the room? You know, listening to this. You've got to go up against this. In just a few moments, he'll be up there arguing against this. It's a tall order for anybody.
That she was the critical connection between the trigger man who gunned down Dan in his own garage, Mr. Garcia and Luis Rivera, who pled guilty, and the members of the Adelson family, including Charlie Adelson, who allegedly commissioned Dan's murder. In our view, additional evidence to be presented at Mr. Adelson's trial, including the enhanced Dolce Vita audio recording, leaves no doubt that Charlie Adelson commissioned Dan Markel's murder. We are confident that a jury will agree and convict Mr. Adelson. The evidence putting Charlie Adelson at the center of Dan's murder is, in our opinion, devastating and inescapable. For starters, Ms. Magbanoa has already testified that she believes Charlie Adelson was involved in Dan's murder. Wendy Adelson, Charlie Adelson's sister and Dan's ex-wife, testified Charlie Adelson had explicitly talked about hiring a hitman to kill Dan, but bought her a new TV instead, because it was cheaper than hiring a hitman. In the days and weeks before the murder and on the date of the murder, Ms. Magbanoa and Charlie Adelson were in frequent, regular contact with each other. Ms. Magbanoa often communicated with Mr. Garcia and Charlie Adelson with Donna Adelson in close proximity to those calls. During the 90 minutes immediately after...
Thank you very much, someone, for those 5 cups of coffee on buymeacoffee.com. Rain Panel. Thank you, Rain Panel.
After Dan's murder, Ms. Magbanoa communicated with both Charlie Adelson and Mr. Garcia. Mr. Adelson and his mother, Donna Adelson, also spoke during that same time period. Then, in the weeks and months after Dan's murder, Ms. McBanois received thousands of dollars from the Adelsons, including paychecks for a no-show job at the Adelson Institute and a car. In April 2016, undercover law enforcement contacted Donna Adelson about Dan's murder, handing her a flyer about the murder with a request for $5,000 to help Mr. Rivera's family. Donna Adelson's first call after the undercover bump was to Charlie Adelson. She explained that a man had handed her some paperwork that involved probably both of us, probably the two of us. You probably have a general idea what I'm talking about. Charlie Adelson said, "What did they ask?" And Donna Adelson responded, "This TV was probably about 5, apparently using the code word TV to refer to Dan's murder." Donna Adelson told Charlie Adelson that the undercover...
No, that was happenstance. She could have picked any object in the world. She could have said, "This bowling ball is going to be about 5.
Agent had mentioned an ex-girlfriend, but did not name Ms. McBanois. Yet, after the call, the specific ex-girlfriend that Mr. Adelson called was Ms. McBanois, with whom he then met in person to strategize about how to respond to the undercover bump. Law enforcement recorded that meeting at the Dolce Vita restaurant. Among other incriminating statements, Mr. Adelson told Ms. McBanois that the individual who contacted his mother didn't mention his name, which led him to believe that these people only know part of the story. And of course, no plausible explanation has ever been offered as to why Mr. Garcia and Mr. Rivera, two gangsters from South Florida who had no connection to Dan Markel whatsoever, would have killed Dan, other than the obvious one. They were hired by members of the Adelson family through Ms. McBanois, the only known connection between each side of the murder-for-hire conspiracy.
It is that simple, isn't it? That's Occam's Razor 101. That's just like, yeah, okay, so those thugs were hired by the Adelsons through Catherine McBanois to kill Dan. Any other spin you try and put on it, it's like, no. The first option, it's the first option, for sure, for damn sure.
Flight risk. Charlie Adelson is a classic flight risk. He faces charges of first-degree murder, conspiracy to commit murder, and solicitation to murder, and the very real prospect of spending the rest of his life in prison. Mr. Adelson and his family have substantial wealth and the financial means to flee. Recorded telephone calls capture Charlie Adelson boasting about his expensive luxury cars, boat, and international travel. Mr. Adelson even discussed with Ms. McBanois his intention to flee in the event he was prosecuted, evidence of both consciousness of guilt and of flight risk. On the enhanced Dolce Vita recording, Mr. Adelson told Ms. McBanois, quote, "If they had any evidence, they would have already gone to the airport." Sorry, we would have already gone to the airport. This court should not give him an opportunity to make good on that actionable threat. Witness and evidence tampering. There is a substantial risk that Charlie Adelson would attempt to corruptly influence trial testimony or otherwise tamper with trial evidence. Facing the prospect of an effective life sentence and a near certain conviction, Mr. Adelson has every incentive to influence witnesses who may testify at his trial. Some of those potential witnesses, such as his mother, Donna...
June. Need to be straight on the phone with June. What about if you testified like this?
Adelson and his sister Wendy Adelson are close family members who may also be implicated in Dan Markel's murder and may themselves be subject to future prosecution. There is a substantial risk that Mr. Adelson and his family members could strategize, coordinate defenses, script testimony, or work together to influence other witnesses. Any of these scenarios would threaten the integrity of Mr. Adelson's trial, as well as the ongoing criminal investigations of members of Adelson family members and other potential unindicted co-conspirators. Recorded telephone calls capture Mr. Adelson apparently discussing other serious criminal conduct as well, including trafficking in controlled substances, and demonstrate that he is capable of heinous violence toward others. For example, in the Dolce Vita meeting, Mr. Adelson tells Ms. McBanois, when the expletive police show up, and there's an oral surgeon standing there with a dead gang member in his expletive driveway, they're not going to come down too hard on me. And in a May 2016 call, Mr. Adelson discusses his willingness to alter patient records and to lie to his dental patients. After all of these factors, the serious murder and other felony offenses with which Mr. Adelson is charged, the overwhelming weight of the evidence against him, the lengthy prison sentence he faces, and the very real risk that he would flee, the risk that he would corruptly influence trial testimony, and the risk that he would conspire with or be influenced by members of his family, strongly support the denial of Mr. Adelson's motion for pretrial release. In the more than 8 years since Dan was brutally murdered, the Markel family has endured unfathomable grief and loss. Their only son was stolen from them, and members of the Adelson family have not allowed them to have a continuous and loving relationship with their grandchildren, Dan's 2 young boys. Throughout this horror, the Markels continue to fight for complete justice for their son and to be reunited.
And on top of all of this, all of the murder and the lies and the plotting and the using people and the attitude he has, on top of all of those things, he's not even a good dentist. He's lying to his patients. He's paying off the board of dentistry so he doesn't have to do an 8-hour continual learning course every 2 years. He's got bad Yelp reviews, botches every job that comes in. People routinely complain and threaten to report him, so he pays them off. It would be just as bad if he was like this fantastic dentist that was just a bad seed. But the fact that that's not the case, it does seem to make it even worse.
United with their grandsons. The interests of the public and of the Markel family as victims of this heinous crime support the denial of Mr. Adelson's motion. We thank the court for its kind consideration. Respectfully submitted, Orrin Schneider, on behalf of the Markel family. All right, Judge. That's the conclusion of the evidence, Judge, for your consideration of the Arthur issue. I do have a couple additional exhibits I'd like to go ahead and proffer for your consideration if you find that the burden was not met or you choose to exercise your discretion and consider bond for the defendant.
All right.
I have State's Exhibit F, which are some iCloud text messages from Charlie Adelson's iCloud from both 2012 and 2013. These are just messages between the defendant and his father, unrelated to the case, indicating that they have access to a large amount of cash. So the first one indicates, Charlie, I spoke to Mom and we will take the $26,000 in cash. The second one says 27043 business and 3292 in personal. Deposited over $25,000 cash for you in safe. Love, Dad. And the third one reads, I know that. I just need to discuss the accounts. The 2 accounts that I hold have $346,000 in cash and require more time to send for a reason that I can explain if necessary. Love, Dad. And that's marked as State's Exhibit F, Judge.
All right, let's just be clear for the record. Any objection?
No, Your Honor, as long as we can get a copy of whatever she's admitting.
All right, you have a copy for defense?
It doesn't need to be right now if she doesn't have it, just after the hearing.
All right.
The messages have been provided, but in a big iCloud, so I can provide those 3 sheets.
All right, they'll be admitted as Exhibit F.
All right, and then State's Exhibit G. This is a portion of a transcript from a videotape deposition of the defendant in reference to a unrelated civil case that was conducted on December 14th, 2021. And I've included page 1 and 2 of the deposition, 1, 2, and 3 that tell you what it is, where it was conducted, who's doing the speaking, and the table of contents. And then I've included pages 23 through 28 of the deposition, which is relevant to show Your Honor what a more current picture of their financial abilities is at this time. It indicates that Mr. Adelson, the defendant, has sold several businesses to his father recently, and also sort of gives you the status of some of the properties and businesses that he owns. And then I also included page 389 on the back, which is just the certification from the court reporter authenticating this document.
All right, Exhibit G has been offered. Any objection?
No, Your Honor.
Be admitted as Exhibit G.
All right, and lastly, Judge, I just have the PowerPoint that was presented today, which I would offer as just a demonstrative exhibit for the record.
All right, it'll be admitted as demonstrative exhibit.
And just a couple other points on the financial abilities, Judge. I know there were several calls on State's Exhibit 99, which was introduced today as State's B, which discussed the financial abilities of Mr. Adelson and the significant financial resources of his family, but also witness Mary Hull, our financial analyst, testified that between 2013 and 2016, when our crime occurred, Adelson Institute was earning about $1.5 million a year. Charlie Adelson himself was earning approximately $3 million a year. That the family in total had approximately 18 investment accounts, including multiple properties. And then I would also just point out the evidence that was elicited regarding Charlie Adelson doing favors for Catherine Magbanowa, in addition to the car and the breast augmentation, but also vacations, and of course the payroll, putting her on the payroll. May I have one moment to confer, Your Honor?
You may.
In closing, Judge, the state has met its burden of proof evident or presumption great by the great weight of evidence in this case. There is a lot of circumstantial evidence, and the devil really is in the details here, but the statements made by the defendant on those wire calls and in that Dolce Vita recording are very, very compelling, and we would ask Your Honor to hold this defendant without bond, to protect the community, to preclude the potential for flight risk, and to make sure that justice is served in this case. We do intend to try the case relatively soon. The defense and I have discussed a February or March trial.
Freedom for those oppressed by small ear holes. Thank you, Kat. Was it Kat? I think it was Kat. It was Kat. Thank you, Kat, for the coffees on buymeacoffee.com. And Riding Shotgun. Thank you, Riding Shotgun, for the coffees on buymeacoffee.com. Fantastic. Fantastic. Thank you so much, guys.
Date for this case.
All right, are you making the argument that any of these statements in the Dolce Vita video are direct evidence as opposed to circumstantial?
I do think all the statements of a defendant are direct evidence in addition to all the circumstantial evidence.
All right, thank you. All right, Mr. Rashbaum, will you be calling any witnesses?
No, Your Honor.
Just presenting argument today?
Yes, Your Honor.
All right. You
May I
may
approach,
proceed.
Your Honor?
Yes.
Judge, good morning.
Morning.
It's like someone squashed him down. Like he's a little man made of clay. And someone's just squashed him down.
Nothing has changed since September of 2016, when the state allowed a draft probable
Well, it has. He's been arrested.
cause affidavit for the arrest of Mr. Adelson to be released to the media. We've just heard 45 minutes of testimony, and if you look at that draft affidavit, it's virtually identical. Nothing has changed. Sure, there's been convictions.
I'm not sure that was testimony. That was argument. Right? The attorney's not testifying. The attorney is arguing. I'm pretty sure that's incorrect.
Convictions of Mr. Rivera, the affidavit for the arrest of Mr. Adelson to be released to the media. We've just heard 45 minutes of testimony, and if you look at that draft affidavit,
it's arguments.
It's virtually identical. Nothing has changed. Sure, there's been convictions. There's been convictions of Mr. Rivera, Mr. Garcia, Ms. Magbanua, but no.
He does look like a Lego character. It's that same proportion, almost. I bet he loves fucking Legoland. Yeah. But who can afford Lego now? It's crazy how much that costs. It's like, what the fuck? It's more than $100? I don't know. Didn't it used to be like really cheap? I remember just having a huge box of it. Random stuff.
None have offered direct evidence against Mr. Adelson. Ms. Magbanua was offered immunity, a get-out-of-jail-free card, for approximately 7 years. She was offered it several times. All she had to do was give direct evidence against my client. She never did so because there was none. The evidence is the same today as it was back in September 2016, when the then prior state attorney, Mr. Meggs, said this evidence is, quote, mere speculation, lacking probable cause for an arrest. Nothing has changed. And this is a different case than Ms. Magbanua's case. In Ms. Magbanua's case, when Judge Hankerson heard this bond hearing, there was direct evidence. There was direct testimony. The testimony of Luis Rivera. No such evidence exists as of date in this case. There was no arrest in 2016, 2017, 2018, 2019, 2020, 2021, not till days before Ms. Magbanua's retrial in 2022 was Mr. Adelson arrested. For all those years with the same evidence, the state felt that Mr. Adelson was not a flight risk. The state felt that Mr. Adelson was not a danger to the community. Nothing has changed. Now, what does the state say has changed? This supposed enhanced recording, the Dolce Vitae recording. Well, I have all the recordings, Your Honor, and it's the same evidence as in 2016. In 2016, if you look at the draft affidavit, they're relying on the Dolce Vitae recording. Ms. Kappelman herself, just last month, went on a podcast where she admitted that, quote, she always heard what was on the recording, that you could make it out from the beginning if you labored through it. Nothing has changed. In other words, the facts didn't change. And by the way, when the recording is examined closely, as we will do at trial, when it's picked apart, you'll see, without cherry picking, that it exonerates Mr. Adelson. That's what you'll see from the recording. And we're going to talk about the airport comment in just a few minutes. But repeatedly in this recording, Mr. Adelson says that he hopes that the confrontation is the police. That's what he says. If they are the cops, I'm happy because I have nothing to hide. Talk about an alternate explanation, an alternate hypothesis on their best piece of evidence. Repeatedly, he says in their best piece of evidence that he had nothing to do with the murder. He has nothing to hide. He says that at least 5 times in the recording. And I believe he says that a couple more times in the unintelligible parts of the recording, which we're working on making intelligible. The government simply cannot meet its high burden of keeping Mr. Adelson detained. In this case, the evidence is clearly circumstantial evidence, no direct evidence. So the government has the burden under state law of excluding every other hypothesis except that of guilt, which it cannot do. The Dolce Vitae recording itself shows other hypothesis of innocence. Not one single
like the Burger
witness
King thing
establishes.
What hypothesis of innocence was there at the Dolce Vita thing? Oh.
Mr. Adelson's involvement, and Dolce Vitae itself shows his innocence. The wires itself shows the innocence. Now let's use the airport line as an example. So the government comes up here and they read the first line that they have in their intelligible recording. Remember, there's about 30 minutes of the recording before the statement, including a large section which the government says is unintelligible. And the line that they read is, if they had any evidence, we would have already gone to the
Hey, Clarissa, how you doing?
airport. Judge, you have to take it in context. You have to take it into context of what's said before, and you have to take it into context of what's said after. And when you do that, when you dissect the recording, as we will do at trial, you will see that what Mr. Adelson is saying is, they don't have any evidence because I had nothing to do with this. That's what he's saying. But Judge, you don't have to take my word for it.
I just looked up the Lego set available in my local bookstore, and it's of Notre Dame Cathedral in Paris, and it's 175 euros.
And you don't have to take the government's word for it. Because here's what we know definitively, not without guessing of what's said on a recording or guessing what's meant by wires. We know what actually happened. So the Dolce Vita recording happens in April 20th of 2016. That's when this airport comment is made. The arrest of Sigfredo Garcia happened shortly after. Mr. Adelson, he doesn't flee. He stays put. Okay? September 2016, the government releases an affidavit to the press that lays out exactly their theories of the case. Exactly what they just spent 45 minutes telling you today. That release is put all over.
Man, the background of the picture of the Lego could be the courtroom. I thought it was for a second.
The press. 2020, Dateline, Tallahassee News, USA Today, New York Times, the BBC. Does Mr. Adelson flee? Nope. Doesn't go to the airport. Well, actually, he does go to the airport. He goes to places that he could never be extradited from in a capital offense, and he comes back. Okay. October 2016, Miss Magbanua is arrested.
Who?
Sounds like pretty strong evidence.
Magbawa.
Does Mr. Adelson flee? No, he stays here. December 2016, there's a bond hearing in this courtroom, I believe. During the bond hearing, the government again lays out the theory of the case with Mr. Adelson as its centerpiece. Does he flee? Nope. Reports of immunity come out in the press.
I bet he wishes he did. I mean, we know from the jailhouse calls that that's what he was wanting to do, right? And everyone was saying to him, no, listen, we're going to get you the best. We've got Dan Rashbaum, okay, on retainer. He knows this case better than anyone. He's going to get you off. We've got Josh Dubin. We're paying $1 million for Josh Dubin to rig a jury in our favor. We're going to buy our way out of this. But you gotta sit in Leon County Jail for 18 months. You gotta do it. If you flee, that you're exposing consciousness of guilt for all of us. We can't flee. We're old. You know that's how it went down. Charlie was like, they're onto us. I've got to get out of here. I'm going to a non-extradition country. And everyone was like, no, you've got to stay, but we're going to get you the best there is.
They're offering Miss Magbanua, she can get out of jail. All she has to do is turn on...
He's getting close. Magbauza. Magbawa. It's Magbanua.
Charlie Adelson. You heard that testimony. Does he flee? No. Conviction happens of Mr. Garcia. Hung jury of Miss Magbanua. Does he flee? No, he never flees. That should tell you, when you look at the context of this comment, it's taken out of context by the state. And what you're going to see in the trial is many of the supposed evidence that they have, the circumstantial evidence in the wires, on the Dolce Vita video, taken out of context. You don't have to guess what Mr. Adelson meant when he said, if they have evidence, we would have already gone to the airport. They've had all the evidence for 7 years, nearly. He never fled. Now, Judge, even if you somehow find that the state is able to establish its incredibly high burden here, you still have discretion to grant bail and should do so. May I have a moment, Your Honor?
You may.
First of all, Mr. Adelson has no criminal history. There is no doubt about that. I understand the letter from Gibson Dunn, and I understand that they're doing their job. But they can't point to any criminal history. They point to a line in the Dolce Vita recording where Mr. Adelson is talking about how he will defend himself. That is not anything about criminal history, a bad criminal history. There is no dispute in this case that Mr. Adelson, a man of 46 years of age, has no criminal history before this case. During his arrest, he was fully cooperative. As I've just stated, he has never fled since 2016. The state has obviously never considered him for the past 6+ years to be that great of a danger or a flight risk that they needed to arrest him in the last 6 years. Now, this letter also talks about tampering.
But then he still thought he might get away with it. I mean, he was hoping that you'd back off. It's pretty simple. He was just like, yeah, maybe they don't know. Maybe they don't have enough evidence on me. Oh. But he would have seen a bunch of it come out in KD 1 and 2. You know. Yeah. I bet he wishes he was sitting very pretty somewhere with an expensive drink.
Of witnesses. Well, again, the state clearly wasn't worried about that from 2016 to 2022. And I'm not sure what witnesses Mr. Adelson would tamper with. There's been 2 trials. There are trial records of the witnesses who have taken positions.
June, his sister, Katie, his mom, potentially. Jeff, tamper with Jeff.
I'm not sure what witnesses they're referring to. Judge, when looking at taking discretion, you should do a balancing act. I think that's what the courts say. And what I want to bring to the court's attention are the major challenges.
Man, Jeff gave us such framing of this case. You know, it's not all about Jeff, but he changed the way that we're able to see everything else. He framed it. He just drew a frame all around it. Jeff. Jeff's frame. You know, so much would be different without him. And he's only instrumental to this one small portion, really. But even things that he's not involved with, sides to this big equation, we see them differently because of Jeff.
Is that we have in preparing
and Tamara
defense, and for Mr. Adelson to participate in effectively in that preparation of his defense while in jail. And some of this has come to light since our last hearing, and frankly may delay the trial, as you're about to hear. So what I don't know that Your Honor is aware of is since...
Yeah, this Notre Dame thing. I mean, sure, would that be fun? Yeah. Once. I mean, are you supposed to just leave it set up and then have it like on display? Your achievement. Or do you just set it up and leave it out for a day and then break it all apart and put it back in the box and do it again next week? I mean, it's sort of like a one-time thing, really, isn't it? And it's not going to take you that long. An hour, couple of hours, no more than like one afternoon. It's not a multi-day project. So $230 for a Lego, what do you call it? Notre Dame Cathedral? Yeah. I can think of better ways to spend $230.
Being arrested, Mr. Adelson has been in protective custody. What that means is that he is in solitary confinement. And he's in solitary confinement because of the publicity of the case. The prison thinks that's the only way to protect him because of the publicity of the case. As a result of that, he is allowed 30 minutes a day outside of his cell. On weekends, he sometimes doesn't get out at all. He has phone call capability, but those phone calls are during specific times in the day. And the phone calls get cut off after 30 minutes. He has to recall. There's also a high cost to those calls, but that's not an issue here. We filed a motion with the court to allow him to listen to some wires. I'll tell you what we've been doing, Judge, is we spend as much time as we can going through wires with Mr. Adelson on our phone call, where we literally are sticking a computer near the phone and then trying to go through it. As you can see, it's not ideal, but we're doing the best we can. Your order said to the prison that they should use reasonable efforts to allow Mr. Adelson to listen to these wires. So we provided the prison, and they received it on, I believe, August 23rd or 24th, an MP3 player with these wires. Now, these wires are around, give or take, 600 hours of wires. Those don't include the wires related to Luis Rivera and his separate case, but related to this case, they're around approximately 600 hours. Since August 24th, Mr. Adelson has not been allowed 1 minute to listen to those wires. And when I spoke with the jail yesterday, they informed me that he would be allowed soon to start, but that because of a shortage in staff in the prison, he would be allowed 3 hours a week to listen.
You know how sometimes we come up with big scheme ideas for the channel, for the brand? Well, or just things that should be done, like, you know, long-term projects, like the Adelson action figures, right? Got to go to, you know, product design and, you know, the whole thing. It's just long-term project. But what about, you know, a section of Legoland dedicated to the memory of Dan Markel, Professor Markel? where you could have a Judge Everett made of Lego and a Georgia Kappelman, the 3 different faces of Wendy. Just the whole... I've never been to Legoland, but I assume that you walk around and there's different, themes of stuff made out of Lego. I think there's room for a Dan Markel theme.
Listen to those wires. Now, I'm not great at math, but we can do the math. 600 hours, if he gets 3 hours a week to listen to wires, it's going to be pretty hard for him to hear all the supposed evidence that's against him. We've also been told that we have to go through special channels and speak to the chief of the jail to get a computer in the prison for us to use with Mr. Adelson. So, for instance, the videos today, Mr. Adelson has never seen. We have. The government has been terrific with discovery. We have no arguments with the government. They've been terrific getting us discovery. Sure, there's bumps in the road. They've helped us through it. So we have no arguments with the state. Mr. Adelson, we can't get a computer in to show him videos. He obviously can't get a computer in. We've been told we have to call the chief of the jail. I've called him now 36 times. I've gotten 1 call back where he said he would get back to me. We'll keep trying. There's a 2-hour limit on attorney visits with Mr. Adelson without special permission. And I've been told that the special permission is hard to get, again, because of the shortage in staff. There are, by my estimation, 57,542 documents that have been turned over to us in discovery. Not pages, documents. It took the jail 1.5 months for us to get Mr. Adelson the 3,500 pages of trial transcript from the first trial. And the reason being is we can't just FedEx the trial transcript that's given to them. We need to FedEx it to them, and then they need to make photocopies of it. So imagine all the other 56,000, 57,000 and change that we haven't been able to get him yet. The jail just doesn't have the capacity to make photocopies of such items. And we have no other way to go through such items with Mr. Adelson. Judge, we are working hard. We are doing everything we can. We're having, as has been reported on the media, hours and hours and hours of phone calls with him every day. But there's only so much we can do under these circumstances to effectively prepare our client for trial. And there are appropriate conditions to his release. Home confinement, monitoring. We'll pay for 24-hour police security to watch him at the house. We'll tie up any assets that you think need to be tied up. He's been free and has not fled, has not committed a crime in 2016 and onward. There's no reason to believe he will do so now. That's why we're asking for a bond, Your Honor.
All right, thank you, Mr. Rashbaum. All right. The court is in a unique position here because I sat through the other trial, which is what has been offered into evidence by the state, the entire trial and evidence from that trial, the wire calls, the recording from the Dolce Vita meeting, the recording from the Matsuri meeting is additional evidence that has been reviewed and by the court today. Also, there's some iCloud texts and depositions that has been presented to the court today. So I have reviewed all the evidence, so I am in a position to make a ruling. The court finds that based on the evidence provided by the state, that the state does meet the standard of proof evident or presumption great that the defendant has committed the 3 charged crimes. Not only is there direct evidence the court finds from the Dolce Vita video and statements made therein, but there's also a wealth of circumstantial evidence against the defendant. Even if a court subsequently finds that there was only circumstantial evidence, I find that the evidence presented by the state certainly rebuts every reasonable hypothesis of innocence. So I find that the first part of the test is met, and proof evident or presumption great standard is met by the state. Secondly, the court will not exercise its discretion to release the defendant due to the nature of the crimes. I find that he is a danger to the community. I additionally find that he is a substantial flight risk based on the evidence that's been presented. Particularly concerning is his statement in the Dolce Vita video about getting to the airport, if there was any evidence, but there is also other evidence that he is a substantial
now
flight
that there
risk.
is evidence,
And
he
so
might
therefore
go to the
the court will continue to hold him no bond at this point. Mr. Roshbaum, I acknowledge the difficulties that you have in preparing.
Charlie probably thought he was really getting out. He was like, yeah, Dan, he's the one to fix this. We'll send Dan in to schmooze the judge, to sweet talk the judge, charm the judge.
For trial, and I'm going to assist you in any manner that I can within the confines of what's required at the jail. What I propose is that with what you have detailed to me in your argument today in regards to
well, this is good, Pinter.
Your client not being able to...
And Donna's going to be having the same thing in a couple of weeks, 13 days. And she's going to be denied, obviously. I don't know why they're bothering. They should be preparing for trial.
To listen to the wire calls through the MP3, which I had ordered before specifically, the use of the computer in the jail, your limit on attorney's visits and the time that's required for that, and your need to get documentation to the defendant. I think I've identified those particular 4 things. If you could put that in a motion and offer in that motion what you think is a reasonable, or what you're requesting, so that you can have preparation time with your client and review it with the state. I don't think the state's going to have any issues with most of the things that you propose, because I think that they want to move this forward also. I will assist you in any manner whatsoever with contacting who I can within their limited resources at this time, but I think we do need to move it forward, and sometimes it might take an order from the court in order to do that. So put it in a paper motion with the proposed order. Make sure that in that motion whether or not there's any objection to the state, but I've identified those 4 things. If there's any additional ones that you need for your preparation that are reasonable, I think these are reasonable, then also put those in your motion. We'll consider it. I don't think we will need a hearing on this. If we do, then I'll hold that hearing by Zoom so that we can get it done quickly and efficiently.
Thank you, Your Honor.
Okay. Ms. Kavelman, so that we're clear for the record, if you could please prepare a short order that says, for the reasons stated on the record, that the motion for pretrial release is denied, and then that way we have it clear in the record for any further review that's necessary. All right, so the next thing that we have on the docket moving forward is we have a case management in December. If we get this motion and some action from the jail, then I think at that time we'll have a better indication as to whether or not we'll be ready for trial come February or March. I've been looking at dates for that. The one consideration in March, and I don't think it's for the convenience, it's not for the convenience of the court or really for anybody sitting here, but spring break is in March, and so we have to think about that in terms of getting jurors and whether or not it's going to interfere with those plans. So I think that's later in March, so I was looking at dates possibly end of February, beginning of March. But let's have a better idea. If we don't do it then we're probably looking at April or May, because we can't do it in late March. We're just not going to have the jurors. It's just going to be too much of an inconvenience for them. We're already dealing with enough issues in regards to getting jurors. So let's keep that in mind. And I think we'll have a better idea of where we're headed at that case management, so that we can definitely blank out some dates then, either end of February, beginning of March, or if we're heading into April or May. Okay, any discussion in regards to that? Ms. Kappelman?
No, Your Honor.
Anything from the defense, Mr. Rajbaum?
No, Your Honor. I think we'll have a good idea in December.
All right, great. If you can get that motion to me as quickly as possible so we can get moving on these for you, and then we'll be in a position to know come December. All right, Ms. Kappelman, anything else for the court?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, thank you both. We'll be in recess.
Very good, Judge Wheeler.
If May had any of that, she would have already got under more. And the problem is, even if they log this, even if they bug your home phone, nobody's
Even if they bug your home.
even if they even if they bug your phone, then you know, you're something on that. So my point is, how do you get people to talk? You throw smoke, and then you get all the cockroaches to run out. There's smoke in the house, smoke in the house, and everyone's running and everyone's talking. You throw a smoke grenade. What do you think? If that's what it was, it's very smart, because my mom had to call my dad, and he had to my mom said my dad should have looked out when he like that. Yeah, but my mom hasn't told my dad anything. But normally, obviously, if that was a cop, he was supposed to that night, when he comes home from work, he would say, yes, that's coming. But then he made me a little visit when I'm taking the grandkids to school. And then, after I dropped them off, she was walking. Yeah, she dropped them off and I was walking back by herself. So the person had to be with it. I think is a lot of times a mom takes their car, drives to the school. The kid, this person knows her routine, knows who she is. Yeah. Someone may talk to the office. My dad works Monday, Wednesday, Tuesday, Wednesday. Like, you know, he'd probably either get him on the beach or get him at the office up there. And me approach my mom because my dad maybe some less carries a gun. You never know. So, you know, you don't want to turn into a fucking shootout, you know? Well, I mean, I can tell you, a lot of times I carry on me. I mean, someone comes up to me. She carried on you right now? I mean, I'm going to start carrying one on my back. Like, you know, the holster that's just in your back. Someone comes up to me, they're going to be ready to shoot. Someone comes up to me, asks me for money in my house. Yeah, and when the fucking police show up, and there's a doctor, there's an oral surgeon standing there with a dead gang member in the driveway, they're not going to come down too hard on me. I'm not going to talk anyway. I don't know much, and I don't trust them.
Oh, I bet he'd have loved that. You know, yeah, no. I told him to show me his hands, officer, and he didn't comply. I had to put him down. Yeah, he'd love that.
This is not like some shit going off tattoos to your man. Like, this is actually because people are going to come back. They didn't go through trouble of taking my mom out to see that, and then go away. So I got two options. So they're not going away. I mean, if we didn't go away, never come back, they ain't going away. The trouble they wait. What they're now is with the beard or with the badge? Well, I don't know. If a badge comes up to you, I'll have a nice day off. So if they want to charge you with something, charge me. If not, I don't talk to cops. Sorry. You know. No, it's very simple. It's like, if you're going to charge me, charge me. Yeah, but things have changed a lot, though. You know what's changed a lot? There's cameras everywhere. So cops now, they have a fucking pension. When they retire, they're going to get a pension for the next 30 years, medical, dental, and salary every month. If they think that, you know, the camera, look, how many cameras are in here? 5? You know, I mean, they better be doing it in a place where there's not a chance that someone just have a camera pointing outside the building they captured it or their dash. What I'm saying is that this person is not going away. They came very equipped with details. Where the details come from, I don't know.
Hey guys, we've just received a Jeff Lego. Check this out. If Lego made Jeff Lacasse. Can we get a soundbite of Jeff Lacasse? Well, we went down to Markley, alternative spring break. Everybody in that family has a total lack of empathy for other people. It's real quiet in there. Oh.
There's good details on it. Well, because one of the things, you go to the hospital, you have a maintenance. Okay, I'm going to tell them that my brother is dead. I'll do it right now, tell them. They're going to say, did you prove it? And I'm going to say, no. You know what kind of gun was used? They say no. You see your brother doing it? No. How do you know he used it? He told.
There's Wendy. As a Lego. You see? Of course, we'd have to paint that suit on. She'd have to be wearing that suit. That would be like the special edition Wendy Adelson wardrobe for Lego bricks. For Lego people.
Okay, he told you. That's all secondhand knowledge. It's not even admissible. He told me. What did he tell you? He said I did. Even if I went in and said, our brother said he did it, you can't prove it. You got to put the person in the scene. You understand? In order to prove it, you have to put that person at the scene of the time, not in the car. Because the fact is, it's like, even if, let's say, we just have my car, right? And then I go ahead and I commit a crime, and then I go, and your DNA's in the car, and I go, yeah, Katie was in my car, and she got out, and she did this horrible crime. Okay, then they come and they get the DNA in the car, and they go, yeah, Katie was in the car. No, Katie sat in the car for 2 minutes, got out of the EC, and then got out of the car. Katie has nothing to do with the murder that doesn't exist. So even if I could prove that, yeah, Katie was guilty, Can you put Katie at the burger? Can you put Katie, not say that she put out of the car, yeah. What you do is, you have a little bit of that, where you have it in the car, and then we at least if you know, you are going to have money on, you know, such a thing, you were in that bus. Even if your DNA, your fingerprints, fucking hair all over that car, that proves, yeah, congratulations, you were in the car. It's not a crime to sit in a car. I get it, you know what I mean? My mom just out of the car because it's not a crime. You have to prove it to put you in the scene and the date. The guy's name was Tuco. I don't even know who the fuck it is. It's Tuco. Tuco's parcel now. And I knew that you could help it out with your family.
Got Luis Rivera here.
Kelvin, now, she says, damn, he's your help. I was like, I don't know what you're talking about. He goes, well, maybe this will refresh your memory. I handed it to her, and maybe I love it. He also, like, his wife is polite and well spoken. I said, did he have, like, did he act dog, or did he have talk with, like, a thick Spanish accent or anything? She said, no. I said, is he white or Hispanic? She said he was white, but he could have been Hispanic, but no. Yeah, that's his name. I mean, everyone in Miami is Hispanic, so it's like, you can't tell. I talked to you on the phone, so I talked in some way. Maria from West Side Story. But it could have been like, so he wasn't, wasn't strong skin. He had the fucking it's like folds down. It was very recognizable. With no glasses, I said, what about like no glasses, no hat, well, she said, well dressed. Yeah, it wasn't like you would have looking at it and be like, oh, no, she said she was more like a shirt and I kind of like a little vest or a jacket. She said he was broad. So I was like, you think my mom's walking this way, your mom goes to the right, he was like this, staying firm. And my mom's like, oh, sorry, sir. Get this. And then she goes, I was like, sorry. And he's like, it's Adelson. I said, yes. He goes, I need to talk with you. Okay, so my mom thought it was like a process over. He just said it was.
Is it okay to not respect the
For $19, I enter your loss, name and address to the fucking funeral. It cost $19 to find out where they probably rented the apartment under their lease. So it's probably in the register or whatever. So it's like, when you're online, it's like $19 or $29.99, find anyone you want. That's all you do. And it shows where they're registered at. And then you locate them. And you go online, you pull up a picture, and you sit outside and wait. And you know what they do for life is that's something online. Yeah,
Is this audio improved? I mean, it's not very good, is it? Yeah, that's probably enough of that. I don't know. Maybe we should leave it there, guys. What time is it now? Yeah, it's 45. Yeah, we could leave it there. And then come back tomorrow for, what is it? Yeah, the grandmother testifying in the Colin Griffith case. Got to get through that, then closing arguments, then the verdict, and then maybe back to day 3. Why do we need to do it in order? I want to see the grandmother. Everyone else wants to see the grandmother testify. I still haven't seen the whole thing. Yeah, so we'll do that tomorrow. So come back, subscribe to the channel, like, share, leave a comment, support the channel on buymeacoffee.com. And thank you so much, guys. And we'll see you real soon. Don't be like a Charlie Adelson. Be better than that.